Thank you, Your Honor. And good morning, ladies and gentlemen of the jury. It's been a relatively long week, but we thank you very much for your attendance, your attention, your patience. Yeah, as I said at the beginning, we worked very hard to get here, and we appreciate how seriously you're going to consider the issues as you make your decisions. So you heard a lot of evidence this week, and there are some things that we don't disagree on. One is that Ms. Zong is an immigrant from China who arrived in the United States and moved to Atlanta and initially was able to get a real estate business started and was successful in that real estate business for some period of time. She built 700 Latour Drive. She intended that that was going to be her home, but there's also no question that she used 700 Latour Drive as an investment vehicle. We know that when she bought it from her company Sylvanus for $1, she got $100,000 out. In other words, she took equity immediately out of the property. She later borrowed another $100,000 on the property. She rented the property out. So it was more than just a home. And it reached a point where she decided actually not even to live in what she described as her dream home. But in any event, what was driving all those decisions? She acknowledged yesterday when I was asking her questions, what was it that made her borrow the $100,000 in 2008 against the property? She was experiencing enormous headwinds in her business. Her business was just having a very difficult time during the economic downturn that we all experienced during those years. We know that the result of that was that during 2009, she only had about $8,000 in income. And we saw her profit and loss statement for 2010, which was right in this period when she's starting to have real problems with her mortgage payment, that showed that her business was underwater. One of the more interesting pieces of testimony that we heard this week was one of the first things you heard when Ms. Zong's son took the stand, and Mr. Hadary asked him, "What are we doing here?" "We're here to sue BB&T and Wells Fargo for a wrongful foreclosure." Well, why in the world did he make that mistake? BB&T instead of PNC? You know the answer as well as I do. We all heard about the BB&T litigation in 2010, which was enormously stressful and difficult and hard and impactful to Ms. Zong. She lost her business. The economy turned down. She had a real estate business. The real estate industry was especially hard hit. And the upshot was not only did she lose her business, but she was also targeted by BB&T. And targeted is maybe too strong a word because it was just sort of normal commercial conduct. BB&T had made mortgage loans to Ms. Zong. She couldn't pay them back, so BB&T foreclosed on the properties. When BB&T made those loans, though, she signed a personal guarantee. So she knew full well that she was on the hook for that money. And that document that's in the record, we talked about it with Ms. Zong, makes very clear that from late 2010 through late 2011, the possibility that BB&T was going to sue her for millions of dollars on the deficiency was very real and was part of what she was experiencing. And of course, I mean, what's one upshot of all this? Somebody who's having that much trouble in her business, she's going to have trouble making her loan payments. It's no surprise at all. The upshot of all that was that Sylvanus did dissolve in August of 2011. You'll be given the exhibits that have been introduced. You'll get paper copies to look at back in the jury room. That particular exhibit is JX89, if you care to look at it, just to show kind of that Sylvanus ended business and when it ended business, because when it ended was very significant. It was right around the time that she was stopping her efforts to modify her loan with PNC. And it was right around the time that she was also being pursued in litigation by one of her suppliers, Georgia Brick. And frankly, the evidence is in the record that she was evading service of process because of all the stress that she was under. Okay, so sort of backing up a little bit, the record's very clear that in early 2010 is when, as far as this loan went, she started having trouble. That's when she couldn't make her tax payment. And there's no question that PNC advanced that money for taxes. And there's no question, it's clear that it was for the 2009 payment. So when it came time to figure out what she was going to have to pay extra to cover the taxes, it was necessary for her to pay PNC back for what it laid out in 2009, pay PNC for what it was just about to lay out for 2010, and pay enough to get to, in advance, get ready to supply the money so that PNC could make the payment for 2011. That's just the way it worked out. It was her obligation to pay the taxes. PNC advanced the money at no interest, and it led to an increased payment. So based on all that you've heard, it's no surprise that Ms. Ong was having financial difficulty around the time all this is happening. What is surprising is that she blames PNC for all this. I mean, by now, here it is Friday, you've heard a lot of evidence, and I would say that nothing that you saw, nothing that you heard would suggest that there was anything inappropriate that PNC did. In fact, it was all just what you would expect. I mean, you would hope that if you're having financial difficulties and you need to call your mortgage company, that you're going to get somebody on the phone, they're going to talk it through, they're going to provide information. And sure, there may be going to be questions and there are going to be difficulties, there are going to be frustrations, but you'll have an opportunity to look back at those call notes that Mr. Bevins talked about. They're in, I'll give you some page numbers in a minute, but they're in JX 105 and JX 107. And there are times when Ms. Zong said, everybody was rude, everybody was horrible, nobody would tell me anything. The notes don't reflect that. And you know, they're not the kind of thing you'd want to read on Labor Day weekend, but you'll be back in the jury room, you'll have a chance to see them, and you can make them out. You can see what's being expressed. And what's being expressed is people are trying to answer questions. They're trying to figure out how to help. And frankly, that went on right through 2011. Ms. Zong tried to convey to you that the escrow situation was very difficult to understand. That's a little hard to fathom because Ms. Zong was in the real estate business. She was in the business of buying property, building houses, selling property. So she's paying taxes all the time and she's borrowing money to buy the properties and she's paying back loans. So the concept of property tax and how you pay it, first of all, it's not, I mean, it's kind of, anybody who owns property is familiar with it. But for somebody who's in the real estate business, it just shouldn't have been that hard to figure out. Again, finding things I don't need to talk about any further. You heard a lot of evidence about the payments that were made. The sequence there is, to me anyway, interesting. Her payment increases in November 2010. She makes her first payment that's supposed to be in the larger amount that month, but she only pays the principal and interest. She sends that in, and PNC sees that, and it looks as though, okay, a little confusion. This is a person who's only been paying principal and interest for years. So we'll apply the principal and interest payment, but we'll remind her there's more you have to pay. So they send her a letter. It's that November letter that you saw a lot. And PNC says, please send us in the money. She doesn't do that. And I would say that that's where we've got sort of a snowball on top of a hill that's going to start rolling from here. Because from November on, she never submitted enough money. And it got to the point where it wasn't even close. So first month, it's like, okay, we'll apply it to principal and interest, but you need to send in your escrow. She doesn't. So the second month, she does it again. And this time it's not like, okay, we're just going to apply it to principal and interest. They say, okay, what we're going to do is we're going to give you some time, get us the rest of the money by January 4th. If you don't, then we will apply it to the escrow shortage, all the money that we've already advanced to pay your taxes. PNC is authorized to do that. It's in the security deed. It's JX8 is the security deed. If anybody really wants to wade in, it's paragraphs 2 and 3. So that's what PNC says. And once again, she doesn't pay the money. It happens again in January. And I'm not going to go through all of this, but just to sort of skip ahead. I mean, and here, by the way, is the place where she was making a big deal out of people being rude and difficult and uncooperative. You'll see in the exhibits that that's not supported. But in any event, there is a conversation in January, and PNC expresses to her that we can't do what you want us to do. We can't put the escrow on the back of the loan. What we can do is we can spread out the shortage. And that's in a note. I'll have to find it in my outline, which exhibit it is. But it says that explicitly. And that's a big part of the case because she's trying to say that PNC told me that this is going to be fine. I'll just make one payment and I'm fine. That's not what she was told. And that note says it. She was told we can't do that, but we can make your payment lower by reducing it. Okay, so then the escrow analysis gets done. PNC didn't have to do that. I'm not saying, the bank is some saintly organization. The bank is a bank, but the bank is doing things that are reasonable. They're not taking some ridiculous hard line with its customer. They didn't have to do the escrow analysis. They could have just proceeded and let her default and do a foreclosure. Instead, they say, okay, we do have a way to reduce your payment. We can make our 1-year interest-free loan a 5-year interest-free loan, and you can pay it back over 5 years. How's that? She says, okay. Apparently she doesn't understand. I'm not sure what's happening in Ms. Zong's head. That doesn't really matter. I mean, what really matters is whether there's liability based on the facts that have been presented. And you heard a lot about the coupon book. And I think it's pretty clear what happened with the coupon book. Mr. Bevins explained that there was an effective date on that escrow analysis. This payment of $38.91, effective date is December 1st. So a coupon book is sent and she tries to make 2 payments in that amount. And she tears off the first 2 coupons and sends it in with a check. And they come back to her, as you heard. But the upshot is that when she stops making payments, she's at the February 1st, 2011 payment. So she tried to say, oh, this is proof that this was the first payment I was supposed to pay. No, that was the 3rd payment she was supposed to pay. And she sent in those coupons. And frankly, if I've just been advised that JX46 is the note that explains what PNC advised her about what it could and could not do. Thank you very much. What I was about to say was a piece of evidence that you did not see is the original coupon book. That's hers. PNC didn't have that. That was her book. She tried to make you believe that based on the photocopy you saw that it started in February. If you saw the original, we'd be able to tell whether 2 had been torn out or not. You don't get a chance to see that because it wasn't shown to you. But what does make sense is that she did tear out 2 coupons. She's been using coupons for years, and she did it with those 2 payments and sent it to PNC. And as you heard, those payments came back because she wasn't paying enough to come current. So what happens next? She gets into what's known as a workout situation. And once again, PNC is, as far as I can see, acting very reasonably. There was a foreclosure referral, but then there were conversations with her attorney, and PNC says, okay, well, we can cancel the foreclosure. You want to try to reinstate? You want to try to work things out? Fine, let's do that. So there are discussions. There are several months of efforts where documents are submitted and all that sort of thing. In order to qualify, she's got to establish that she can make the payments going forward, but she can't. I mean, we see that she doesn't have money in the bank. She doesn't have an operating business. She's just got no source of funds to make the payments. So PNC receives the information in and says, deficit in income, we can't modify your loan. She tries again, and this is where we get the profit and loss statements, and where we get Ms. Zong saying to PNC, quote, this is in JX65, I hope the lender grants an affordable payment plan so I can keep my house. Doesn't sound like somebody who's saying, we had a deal. You knew that you weren't supposed to do it this way. Sounds like somebody who understands she hasn't been making her payments and is hoping for some sort of a solution, but it's not there. You heard a lot about PNC never giving an explanation. And there isn't much question that this is a somewhat extra complicated mortgage loan situation. So Mr. Hidari asked questions, Ms. Zong had been asking questions, and somebody at PNC, if we could put up JX81, please. Somebody at PNC puts together this very nice letter that lays it out in chronological, I think pretty clear language. It's coming up on the screen now. You can see it in the book. I'm not going to take it line for paragraph by paragraph. Ms. Stammer, if you could put up the last page, please. The very end of this letter, after it's sort of gone paragraph by paragraph, month by month, transaction by transaction, Ms. Zong is specifically advised at the very end of the letter, as of the date of this letter, the loan is due for the December 2010 payment and is active in foreclosure. I mean, that's clear as a bell. And of course, at this point, Ms. Zong is 8 months behind. And what happens after this? Nothing. I mean, there's nothing after this. I mean, there's no communications from anybody about anything. No questions about this. No, okay, well, maybe I've got another way to approach this. Nothing. So who would be surprised under this circumstance that 5, 6 months later, there's going to be a foreclosure? What else would happen? And of course, that is indeed what happened. We talked a little, I've already talked about the other details, but I do want to give you some joint exhibit numbers. Joint exhibit 81 and 84 are letters that are sent in the August timeframe that make clear, hey, you can still get stuff to us. We'll consider it's a try, but nothing comes back. And one of those letters, I think it's 84, makes clear again, this is active in foreclosure. That's sort of the road that we're going down. You know, one person we didn't hear from at all in this trial that I thought we would hear from was her husband, Amir. He was supposed to testify, but didn't appear. I would have had some questions for him. He was obviously involved in this time frame with the discussions that you did hear about. Part of me is sorry I didn't get a chance to ask those questions, but I do think that you heard enough. So what's Ms. Zong's situation as of late 2011? Her sister actually had a very nice phrase for it. Too late. What happened? Too late. Time passed. She wasn't able to get it together, and the foreclosure happened. It was just too late to do anything. Were there other things she could have done? Could she have talked to her family members? I mean, I suppose so. And her sister certainly made clear that that is something that maybe she should have done. Her sister certainly thought so, but she didn't. So the upshot was too late. And frankly, you know, I hope a number of us haven't been through this circumstance, but if you haven't been through it yourself, you probably know somebody who has. This kind of a financial situation starts small and gets worse. It just sort of starts and it rolls. It's a snowball rolling downhill. And by the time the foreclosure finally happened, Ms. Zong hadn't made a mortgage payment since December of 2010, and it was March of 2012. So, of course, foreclosure was the upshot. Okay, so the foreclosure. Georgia law operates as Georgia law does, and different states do this differently. And I'm not going to give you a little 5 minutes on different states' approaches, but Georgia's approach is to just let the parties handle it. You know, some states let the courts handle it. You have to go to court if you want to foreclose. Not in Georgia. In Georgia, the security deed is signed by the homeowner and grants the power to the lender to sell the property upon default. And really the protection Georgia law provides is the notice protection. But the protection is limited. The protection is limited to making sure that it contains the information that's required and that it's mailed to the appropriate address. The statute says if you mail it to the property address, that's enough. And we heard Mr. Olson, who was responsible for the work of the law firm that sent out the notices, who explained in nice detail each of those 6 exhibits, 97A, B, C, D, E, and F, that went out to Ms. Zong. The first 2 required by federal law, the last 4 by Georgia law. He didn't have to send 4, he could have sent 1, but he sent 4, trying to be careful. The one that I think is most illustrative is 97E, because that went by certified mail to the property address, and it didn't get to Ms. Zong because Ms. Zong allowed her forwarding to lapse. She wasn't at the property. The last page of that exhibit has this address that they've made such a big deal of, 3000 Alabama Avenue, Suite. It says that's where we want to deliver this thing, but we can't because We don't have a forwarding instruction to make that happen. None of that really matters because of how Georgia law operates. Mr. Olson made clear, and he's 100% correct. Once we mail it to the correct address, which it did, notice has been given and notice is sufficient. We've heard a lot from plaintiff's side about the notice that they think should have been given, and that's to Mr. Haderi. So in order to make that happen, we would have had to have an instruction, a written instruction from Ms. Zong to do that. Can we see Exhibit 54, please? And now I'm working from memory, so I hope I'm getting it right. But what I'm hoping 54 is the form that Ms. Zong was given by PNC and that she filled out. Yes, indeed, got it right. Okay. So this is going back to March of 2011, and I do want to take my time with this one. Please note that your loan information is confidential and PNC requires your signed authorization in order to release information to a third party. Please indicate below any information that you are authorizing us to release. Okay, I mean, it's a form letter, but it's saying something important there. This is your confidential information. This is your information. So you need to be clear to us what we're allowed to talk to other people about. And she tells them, okay, I want you to talk about general mortgage loan information such as loan balance, next payment due date, payment options. And that makes sense because at this time, March 2011, she's trying to get revised mortgage loan terms. And she wants Amir and Mr. Haderi to be able to talk to PNC about this. Before this point, every time they wanted to talk to PNC, she had to be on the phone. Once she fills this out, they can talk to PNC directly. Okay, that's helpful. The second item, update contact information such as mailing address. She didn't check the box. I mean, that wouldn't have been enough. I mean, if she had checked that second box, there would have been a requirement for a notice saying, don't send things to the property address, send notices to wherever was designated. But it never happened, nor could it have happened because she didn't check the box. She didn't provide this authorization. So what we have left is a letter from Mr. Haderi saying, I represent Fei Zong, direct future correspondence to me. Well, PNC is not going to just say, okay, that means we're just going to share our customers' confidential information with this lawyer. It's going to need the authorization from its customer to say, yes, that's what I want you to do. And after that letter comes from Mr. Haderi, there's months of correspondence. It doesn't go to him, it goes to her. And nobody says, why are you sending correspondence to her? You're supposed to send correspondence to Haderi. Never said. So the notion that that letter is supposed to trigger some obligation to change the address so that he gets notice, a little hard to fathom. You heard a lot about Wells Fargo and US Bank and PNC. And I suppose the suggestion was, gee, maybe PNC didn't name the right bank in the sale process. If that was an issue, it was an issue for these three big banks to sort out. And they did sort it out. And the property got foreclosed on and it got sold and now somebody else owns it. I mean, that might have been an issue among the three of them, but it wasn't an issue to Ms. Zong. It did matter to Ms. Zong whether it was Wells Fargo or US Bank or PNC that was the foreclosing party. She was in default, hadn't made her payments, and had given the power to do the sale, so the sale went forward. I thought about reading the statute that sort of identifies the notice requirements and going sentence by sentence over it with you. I'm not going to take your time to do that. You've already heard it. It's going to be in the jury instructions on page 3. So to the extent you want to really look at what the statute says, again, not the kind of thing you want to read on Labor Day weekend, but back in the jury room trying to sort this out, it's right there. And it makes very clear that the notice that you heard was sent complied with Georgia law. So I want to talk a little bit about the decisions that you need to make. I imagine sitting here, you're kind of wondering what decisions you have to make. What are these? What's our role here? What are the questions? Well, the first question is whether it was wrong for PNC to foreclose on the property. And in order to evaluate that question, you have to decide, okay, PNC owed a duty to Ms. Zong. It didn't perform that duty. And that was the cause of real damage to Ms. Zong. Okay, so the duty is to deliver that notice. That's what Georgia law requires. Did PNC breach that duty? It did not, for all the reasons that I've just said. But we should talk a little bit about the next parts of it too, because a plaintiff such as Ms. Zong doesn't win by proving that there was a duty and there was a breach of that duty. She also has to prove that it caused her damages, that somehow that hurt her financially, that there was some compensable injury that she experienced. And the only thing you've really heard about is emotional distress. You know, that foreclosure was such a devastating experience that the result was a lot of distress. All the evidence that you've heard indicates that there were a lot of reasons for her distress. And was the foreclosure on the property that she was renting out but was actually vacant at the time of the foreclosure sale, was that the problem? Or was it the mortgage loans with BB&T that got foreclosed and the overwhelming stress of the possibility of a deficiency and losing her business and not having any income, worrying about her children? I think you can safely conclude that if she experienced emotional distress, it was not caused by anything that my client did. It was because of all these other things going on in her life. But interestingly, emotional distress, I mean, you might be surprised that that's something that you can award money for. How in the world do you come up with a dollar figure for that? Well, Georgia law says you can do it, but only in appropriate cases. And the appropriate cases are when the defendant has engaged in just horrible conduct, such horrible conduct that it's warranted to let the jury figure out how much money she should get for the emotional distress that she experienced. PNC's conduct has to have been intentional or reckless. It has to be extreme, outrageous. This is going to be in what the judge tells you need to consider. There was nothing that PNC did that was intentionally wrongful toward her, let alone extreme and outrageous. I mean, the worst that we heard from Ms. Zong was when she said that somebody said, hold on, a little frustrated on the phone. Has any of us ever had a moment when somebody talking to a customer service rep on the phone expressed a little frustration and he didn't like it? I think we probably all experienced that. Doesn't quite qualify as the kind of extreme, outrageous conduct that warrants you to award her this kind of damages. I mean, similarly, she wants you, the jury, to punish PNC. And Georgia law says in appropriate cases, the jury can award punitive damages, but you've got to be convinced. You've got to be convinced by clear and convincing evidence that what the defendant did, what PNC did, shows willful misconduct, malice, fraud. It's got to be bad. It's got to be something sort of targeting Ms. Zong and inflicting some sort of an injury. You heard everything that happened. And she and her representatives were talking to people working in cubicles, trying to figure things out. Those were the interactions, and receiving money and trying to figure out what to do with the money and sending letters saying this isn't enough. That's just sort of what happens with loan transactions. So punitive damages are not something you should award. Georgia law has an interesting statute that you're going to hear about. It permits you to award attorney's fees under some circumstances if the defendant's conduct was in bad faith. It requires a showing of, again, similar language I've been using, dishonest purpose, conscious wrongdoing. If PNC, when it was servicing her loan, was deliberately, dishonest in communicating with her, then you could consider, okay, that's bad faith. Let's decide whether it was, and maybe she gets her attorney's fees. The evidence simply doesn't support that. So we would ask that you also make a finding that bad faith has not been proven, and therefore PNC is not responsible for paying Ms. Zong's attorney's fees. There's one last claim that I need to discuss with you. It's a very legalese kind of term. Promissory estoppel is the term. It's a legal mechanism by which somebody can come in and say, somebody made a promise to me. They should have known I was going to rely on it. I did rely on it, and I was hurt. And the classic example is if somebody offers you a job, you move from Atlanta to Savannah or whatever. You sell your house here, go to Savannah, and you don't have a job. You say, oh, sorry, no job. You can say, wait a minute, you promised me a job and I sold my house. That's the sort of circumstance that allows you to bring this kind of a claim. So in this case, Ms. Zong is asking you to find an instance where PNC promised something that PNC should have known she was going to rely on, that she did rely on, and that it hurt her. I mean, the closest thing is when there was discussion about what she can do with the escrow that has to be repaid. But there's no promise made there. In fact, Exhibit 46 says, we advised her we can't do that. But what we can do is reduce her payment a little bit and spread it over 5 years. So you'll hear what a promissory estoppel claim is. You'll know from the evidence that there was no promise and none of it's satisfied. Ms. Zong said something interesting yesterday, and that was that back in 2011, she didn't use the money that she had to pay her mortgage. She used it to pay her attorney. She paid him a lot. That was a choice that she made. She did make her mortgage payments. Foreclosure resulted. It wasn't wrongful what PNC did. I request that you return a verdict in my client's favor. Thank you very much.
Mr. Howard, whenever you're ready.
Thank you, Your Honor. Good morning, ladies and gentlemen. I want to start by saying that I appreciate your superhuman levels of patience that you've displayed this week. It's been a long week. We've heard a lot of witnesses. You've seen a lot of testimony. And as I'm sure you can tell, my client, Wells Fargo, and I are sort of a third wheel in this dispute between Ms. Zong and Wells Fargo. I've been sitting over there listening almost as long as you guys, or almost as much as you guys have been sitting here listening. I think we both have a good understanding of Ms. Zong's story, of what she went through, and the circumstances that really led to her loss of the property at 700 Latour Drive. And I think I've said I'll be brief about 30 slightly different ways. I'm not going to change now. I appreciate you guys laughing on the inside, not the outside. But I'm not going to change. I'm still going to be brief. I'm going to say my piece. I'm going to sit back down. Mr. Hideri will say his piece, and he'll say that, and you guys will finally, after 5 long days, get the case to consider, apply the facts that you've heard, apply the law that the judge will tell you the facts you've heard, and make some important decisions. Now, as I've said, I think we both have a good understanding of Ms. Zong's story. And in a lot of ways, it really is an inspirational story. She traveled across the world to come to America to find the American dream, to have a family, to raise her kids here. And she did that. She came, she built a business, she had kids. You heard from her son and some other family. Her son obviously loves her very much. I found that very touching. There's no dispute about any of that. And one of the things you heard from Mr. Hideri and from Jason, her son, was the pride that she had in her business in Sylvanus and these houses that she built. She testified, and I think you guys heard that some of the houses she built for Sylvanus were a little too big. You know, the finishes she liked were a little too grand for the market sometimes. I mean, she liked the nicer things. You know, she wasn't happy with the marble she could find here. So she'd go to China or Hong Kong and she would source this perfect marble. It was the envy of all these other builders, architects and folks that she knew. That's what she told you. And it worked for years. She built a bunch of houses. Sounds like she was wildly successful. And she took that success and she built a property that she told you about at 700 Latour Drive. And her son, Jason, said that that was not a big house particularly, but it sounds like it was incredibly nice. You heard about crystal chandeliers, about special balusters on railings. You heard about how she finished the basement in a very, it sounds like a very finely appointed way. You heard about the 18 by 18 travertine tiles that she brought. I think she brought in from Hong Kong and installed. She put a lot of time into that house. She put a lot of money into that house. And you can do that. I have no judgment about any of that. I like the nicer things myself sometimes. I think we all do. We have different things we may prefer, but I'm not judging that at all. It only works as long as business is booming. It only works as long as the money is rolling in. And like a lot of builders, 2004, 2005, 2006, that was the case. And it was the case for Ms. Zong. But like a lot of builders, that changed. And you heard that her business was obviously dependent on the real estate market. It was heavily dependent on credit. That all went smoothly until the Great Recession, until the real estate crash. And you heard that from Ms. Zong and from other folks here too, other witnesses. And it wasn't just Ms. Zong. There's no judgment there either. In 2008, 2009, 2010, a lot of builders went out of business. I have friends who are builders. They went out of business and had to figure it out. And you also heard a lot of evidence about the dramatic effect that that had on her business and on her personally. As Mr. Tobin said, you saw her 2009 tax return that she submitted to the federal government that showed that she personally made a little over $8,100 for the entire year. With the bills that she had, with the debt that she had at that point, that must have been incredibly stressful. You saw her profit and loss statement from 2010 that you provided to PNC. They showed her company in that year lost more than $61,000. That sounds incredibly similar. You saw a couple of bank accounts. She had very little money in the bank account statements. Very little money. Her sister testified about giving her, I think, multiple loans, but at least one loan. She wrote a $20,000 certificate in Zong. That apparently wasn't enough to get her back in the black, but her family was trying to come together and help her out in these very difficult circumstances. And then in August of 2010, BB&T, which Ms. Zong told you was her construction lender, her primary source of this credit that she was so dependent on, all that debt due. And they filed a multi-million-dollar lawsuit, not just against Sylvanus, but against Ms. Zong personally. Again, that's incredibly stressful. She admitted that there was another vendor that was suing her as well. And all of that financial onslaught that came from 2008, 2009, 2010 resulted in her business, her pride and joy, according to Mr. Hidari and some of the testimony, shutting down, closing in 2011. And she summed all that up in a letter that she sent to PNC that I believe is in the record, that she sent in April of 2000. And she herself said that she needed help on her mortgage because her company had no revenue because of the slowdown at the real estate market. Those were the circumstances. That was the downside of Ms. Zong's rise and fall. Things were great. She was building expensive houses. She built her own very expensive house, and things went downhill, and things kind of fell apart like a house of cards. Now, Mr. Hidari made a big point of the fact that Ms. Zong was paying him. I didn't hear any testimony about any other debts that she was paying when she got to the point where she couldn't pay her mortgage. She made a big point of testifying, or he made a big point of presenting the fact that she was paying him. Ms. Zong agreed to that, but I was very interested to hear that what she said after that. She said, yes, I was paying you. I was using the money that I wasn't paying to PNC. So she was not in a good financial situation. She also, there was some mention too of some other accounts that she may have had, of some other businesses that she may have run. Those were never identified. There was no evidence presented about what those looked like. No evidence presented about what those were, how much money was involved. We just don't know. Could have been presented. It wasn't. And when push really came to shove and she went to PNC and said, I can't pay my mortgage, I need help, all she presented was the evidence that you saw. I don't know why she decided she would just present what she now claims was sort of the least profitable, not even least profitable, most, I don't know what the word is, but it was not profitable. But that was the weakest part of her financial picture. I don't know why she thought that was a good strategy. Her strategy clearly backfired because PNC apparently denied her because she couldn't show affordability. But that was her strategy. So there's no evidence about these other businesses. There's no evidence about these other accounts. None of that. What we know is she was in financial, very, very hard times, that the money that she had because she wasn't paying her mortgage was going to her attorney. Getting ahead of myself. So all of that said, all of the evidence that you guys heard for the course of these 5 days points to one inescapable conclusion. The foreclosure, PNC's foreclosure, did not cause Ms. Zong her financial distress. Her financial distress for the 3 years preceding the foreclosure, which happened in March 2012, that caused the foreclosure. And that's one of the big questions you guys have to decide today is that causation. What caused what? And what came first usually causes what comes second. And she was in hard times for years before the foreclosure ever happened. Now, that sort of brings me to the law, and Mr. Tobin covered some of this, so I'll try and continue to be brief. One of the questions you're going to have to answer is whether Ms. Zong proved that she's entitled to an award of monetary damages against Wells Fargo as a result of the foreclosure that PNC performed. I would point out that Wells Fargo has admitted that we're in default in this case, which means they didn't file a timely answer, unfortunately. And so we've admitted some of the allegations in the complaint, and the judge instructed you, and Mr. Haidari read a couple of those admissions, but we have not admitted that PNC's foreclosure caused her damages. That's something she has to, we have not admitted that it was the foreclosure and not all of these other financial issues that caused her damage. That's something she has to prove. Judge McAfee will tell you, or it'll be in the jury instructions at least, that Ms. Zong has the burden of proof on damages. We don't have to prove that she didn't suffer damages. She and Mr. Haidari have to prove that, in fact, she suffered damages as a result of the foreclosure. And as you've also heard, and as Mr. Tobin kind of clarified, there are sort of two buckets of damages she's seeking in this case. One is emotional distress or emotional anguish. She has to prove, she has the burden, she has the sole burden to prove that that emotional distress was caused by the March 2012 foreclosure and not by the financial distress she was suffering in 2008, 2009, 2010, 2011. She has to prove that. And the evidence just doesn't support that. There was some testimony that she was worried, that she was stressed out because she didn't want to be a burden on her kids. I think Jason would agree that she could never be a burden on him. I saw that in his eyes. He's a very loving son. But even if she was a burden on her children, it was not Wells Fargo's fault. Wells Fargo didn't do anything that would cause her to be a burden on her kids. If she's a burden on her children, it's because of BB&T calling that debt due and filing a lawsuit and her business closing. And that's completely unrelated to the foreclosure, except insofar as that what caused her to fail to make payments. And Ms. Zong and some other witnesses testified about a lawsuit. And when BB&T sued her personally, she settled it. And she released claims in that settlement, so she can't sue BB&T for the emotional distress that she's claiming now. She had to look for other folks to sue, and she found them. And as Mr. Tobin said, mental anguish carries a very high burden. You can't award her damages for mental anguish because she lost sleep. You can't award mental damages because she was frustrated by lengthy hold times. Try and call AT&T. That's a fact of daily life. That's not mental anguish. And again, your job is to look at all the evidence. There was argument and testimony that she took such pride in her business, and that failed. So what really caused her emotional distress? You need to look at the timeline. You need to look at what happened when and what caused what. And I think the answer is obvious. I think when you get back there and look at everything, you're going to find that she has not met her burden on this. And I would ask you to award zero damages against Wells Fargo for emotional distress. The second bucket, and I mentioned two buckets, the second is injury to credit standing. And I'm not going to get into a lot of law, but I think Judge McAfee will tell you that to get credit injury, she has to prove that the foreclosure was the proximate cause of damage to her credit in some specific way. And I quote that because it requires some specific evidence of how the foreclosure caused her credit damage. And there was zero. We didn't hear that she applied for a loan and it was denied. We didn't hear that her credit cards had this balance and that was reduced to that. We didn't even see a copy of her credit report. Credit reports are free. You can print one in 5 minutes. We didn't see that. And there was no testimony to back any of that up anyway. There was really nothing. There was some reference, I don't remember if it was her son or not, there was some reference to her going to a store trying to buy a dress for her daughter, and she was unable to purchase the dress, but there's no evidence from Ms. Zong on that. There's no testimony from her daughter on that. And we don't know when that happened. We don't know what store it was. That very easily, based on the evidence you have, it's just as likely that that happened before the foreclosure, after her business shut down, than it is that it happened after the foreclosure. And there's certainly no evidence that it was caused by the foreclosure. And you compare that absolute lack of evidence to all the evidence contradicting the story. as I said, I'm trying not to repeat myself, but her business shut down several months earlier. She made $8,000 in 2009. Because of that lack of evidence, I think it's your duty, and I would certainly ask you to comply with that duty to award Ms. Zong $0 in damages for wrongful foreclosure on that basis as well. If she didn't meet her burden of proof, and when there's no evidence, it's very hard to meet a burden of proof, then she needs to be awarded $0. Punitive damages, Mr. Tobin discussed that. There's a very, very high bar for punitive damages. What I would point out there, there's a very high bar for punitive damages, and as part of the default, we didn't admit entitlement to punitive damages. She has to prove all those same elements that Mr. Tobin covered. And she has to show that Wells Fargo committed fraud or malice, oppression. And what's the evidence? Wells Fargo didn't have anything to do with this case. Wells Fargo didn't have anything to do with the loan. They didn't hire foreclosure counsel. They didn't accept payments. Everyone agrees the testimony was undisputed that Wells Fargo is here because of a mistake, because of a typo that Wells Fargo had no control over. The evidence was undisputed that Wells Fargo never spoke with Ms. Zong and was not even aware of this foreclosure until they were served with the lawsuit. So I would tender, and I don't think this is controversial, based on that record and that lack of involvement, you certainly can't show that Wells Fargo committed some sort of fraud or malice or oppression, the sort of things that are required for that really high burden on punitive damages. Now, if you find, as I expect you will, that Ms. Zong hasn't proven any actual damages that result from the foreclosure and not all the other financial distress she was going through, there will be an instruction on something called nominal damages, which is kind of a quirky little thing in Georgia law. Nominal damages are kind of what they sound like. If you find that somebody was harmed, but there's no actual evidence of real harm, some sort of small issue, or you look at it and there was an issue, but the mitigating circumstances are strong, you're allowed the word nominal damages. Nominal damages kind of means what you think it means. Nominal kind of means de minimis. It just means we felt like something sort of went wrong, so we're going to give a little bit of money. But that determination, as Judge McAfee will tell you, is made by you guys, solely you guys, considering all the facts and circumstances of the case. And again, with regard to Wells Fargo, what are the facts and circumstances? There are none. We weren't involved. Wells Fargo was not involved. Based on that, I would ask that you guys award $0 in nominal damages as well. And there's one more wrinkle. Those are the damages categories. Judge McAfee's instructions will tell you that if you decide to award any damages, if you decide that she's met her burden of proof and proven some damages, then you have to decide what percentage of fault, whose percentage of fault caused the foreclosure. Was it PNC? Was it Wells Fargo? Or was it Ms. Zong and her failure to make sufficient mortgage payments, or any mortgage payments, frankly, for more than a year? The verdict form is going to show you, a line for Ms. Zong, a line for defendants, and you've got a total 100. So you can put 50-50, you can put 100 and 0. But based on the evidence as I've argued it, based as the evidence as you've heard it in the last 5 days, I think the fairest statement is that this foreclosure was caused by Ms. Zong. It was caused by the financial difficulty she was going through. It was caused by her failure to make the property tax payment. It was caused by her failure to make payments after that when PNC was trying to figure out the property tax thing. It was caused by her failure to make payments. Eventually, she stopped making payments completely. I would suggest, and I think once you guys look at everything, you will agree that that was the cause of the foreclosure. The foreclosure was not caused by anything PNC did. It certainly wasn't caused by anything Wells Fargo did. So I would submit, when you see those lines on the jury verdict form, you put 100% for Ms. Zong and 0% for the defendants. So that is basically my case. Mr. Hadari, no doubt, is going to get up, and I have no doubt he'll give a very compelling closing. He's going to talk about how Ms. Zong was financially distraught, how she was injured, how she's a different person now than she was before all this. And you guys are going to feel bad for Ms. Zong. I will feel bad for Ms. Zong. I promise you that. But that is not what you have a duty to base this case on. You don't see a sad lady who's been through some rough stuff and say, this is our opportunity to give her a little money. You've got to look at the evidence, you got to look at the law, and you got to find out who caused what damages and where those damages came from, and make the decisions that'll be explained on the verdict form and in the jury instructions. And that's your job. I have every faith that you guys will do a great job with that, make a fair decision. And again, you guys have been great. Thank you so much for your time and your patience and your attentiveness.
Mr. Haydari, when you're ready.
Your Honor, I need to make a motion outside the presence of the jury.
All right. Mr. Jury, let's take, why don't you approach first, actually? Mr. Haydari, when you're ready.
Ladies and gentlemen, greatly appreciated. This is undoubtedly the most important day that my client has had since approximately 12 years ago when her home was taken. I told you early on that this was a relatively simple case. And at its core, it is. Talked a lot about back and forth PNC in terms of the letters, what it meant and everything else. But that's not really what the case is. That goes to sequestration, that goes to how we got here. And I thought it was important that you hear the story. And I thought it was important that you heard how we got to what we're looking. You have a few claims. You have claims for closure. You have breaking the promise. I'm going to walk you through the claims. And I want to. Before we get there, there's two things I want to add. So first, it's the burden of proof in a case like this. We have the burden by what's known as a preponderance of the evidence. And you administer justice. And when you have the scales of justice, if they're entirely even, and you take a feather and you put it on a scale, that means that my client has met her burden. That's all it takes. The second I want to mention is, and this has happened in other cases, and I want to make sure there's no question about it. Everything you heard on the stand is evidence. Any documents you receive is evidence. But more importantly, the documentation doesn't carry more weight than any testimony you heard. What you heard is evidence, and we did not have to put on a single document. You don't have to take a single document back there. You could have sat here, listened to everything and said, yes, this was wrong, and we're gonna fix it. First claim that we have is a claim for wrongful foreclosure against PNC. And I'll mention Wells Fargo in a bit. But as far as PNC is concerned, we have a few things that they had to do. They had a legal duty. And so we talked about the statute yesterday. You actually heard Mr. Olson, who is PNC's agent representative mailing out the notices. And he said, this is the statute, this is what we have to follow. And there were a few requirements, and we'll jump into that in a second. The second is that they didn't follow those requirements. They breached their duty. They didn't do what the law said they had to do. The third is that it was the proximate cause of the plaintiff's injuries. And we'll talk about what our proximate cause is in a moment. And I'll note that when you go to the back, you're going to have all of these instructions with you as well. It's going to be just a couple of pages, but these ones that I'm highlighting are perhaps the most important because they'll help clarify where we're going and what we're asking. The last one is that because PNC didn't actually do what they were supposed to do, they didn't follow the law, they didn't follow the statute, it somehow caused my client issues and it resulted in damages. So the last one is damage. Was my client hurt by this situation? The next claim we're going to discuss is the breaking of the promise. And there were several promises that were broken. And any one of those promises is in order to come back and say that they broke. So the elements of what's called a promissory estoppel claim, which is a fancy legal way of saying breaking a promise. And the requirements for this are less than an actual contract. That's one thing that Mr. Tobin mentioned in opening. The requirements are less. So did PNC ever make promises to Ms. Song? There's at least 3 promises they made. There's the initial promise, if you make your payment, you're going to investigate. Second promise, the coupon books, make these payments, and then prior issue has been resolved. And then at the very least, there's a third promise as well, where they specify, do this hardship application. This will make this thing go where it needs to go. Someone's going to look into it. We'll get back to you and we'll fix it. The other elements are easy. Should PNC have expected that Ms. Zong relied on the promise? If call your mortgage company and say, we're going to look into it and get back to you, keep doing this. Should she rely on that? Should she believe them? They mail her a coupon book and they say, all these payments. And so take care of it. And we've resolved all of that headache, all of that stress, all of that heartache you were dealing with. Can she believe them? And did she actually turn around and rely on that promise? Did she mail those payments like they told her to mail? Did she follow what the coupon book said? And then fourth, which is your role, is that you cured an injustice. Did Ms. Zong actually rely on this? And did she change her position? Did she actually turn around and mail those coupon book payments like she was told to do? Did she turn around and sit back and say, okay, I'm waiting for your call back? Did she actually rely? Did she believe PNC? One thing that you will also be instructed is that Wells Fargo is in default in this case. That means that they cannot contest liability. They cannot contest that it caused my client harm. That ship has sailed. They cannot do that. There's only one thing that they can contest, which is how much has my client been harmed. And you heard what they just said. She hasn't been harmed at all. She hasn't suffered any pain. She hasn't experienced any anguish. She hasn't been impacted by this. This is all a farce. Going back to the wrongful foreclosure issue. There are two duties that happen. Two requirements of the law that PNC did not satisfy. First one is when they foreclose on their property, they foreclose on behalf of Wells Fargo. And as we heard here, we'll get into some of this testimony later. It was Wells Fargo GSR. According to PNC, this is a typo. They had this typo in every single legal document. You heard Wells Fargo's testimony. They came in here and said, we should not have foreclosed. We weren't the proper party. We are not aware of any such entity that exists. The foreclosure never should have happened in our name. That's the breach of the first duty. That's the first failure they made. And we'll go into that later, but just as a preview. The second one, sending the written notice. They're supposed to send the written notice to the address that was provided by Ms. Song. And that could have come in one of two ways. Could have been through Ms. Song herself, or it could have been through me as her agent. This is a statement of the law. And even though there's a long statute, which you'll also get, this will be in your instructions that Judge sends back. And so you can see in some of those foreclosure notices, it talks about the secured creditor. In all of those notices, it said it's Wells Fargo GSR, which Wells Fargo is now claiming is, something that doesn't exist, which PNC is claiming was the typo. That's right, we're sending you these legal documents, we're gonna take your home. And every single one of these legal documents, it mentions an entity that doesn't exist. A typo is when I spell Faye's name, F-E-I, or I spell it F-I-E, or I maybe make a mistake, add an extra comma, that's a typo. These are requirements of the law. And for some reason, you think they don't have to follow. If you turn around and then I go to the bank and I say, I'm going to withdraw money from John Doe's account, that's not a typo, that's fraud. It's fraud. And because of that fraud, my client lost her house. She turned around and she sued Wells Fargo. She turned around and she sued PNC. That's what she did. The second component is that they must send notice to the property address unless the debtor designates in writing another address. This happened in two ways, and we'll go through some of the proof in a second. First, Ms. Zong, she herself sent in the coupon book address update form. I'll show you that in a moment. And second, through me, I sent notice to PNC saying that any and all disputes regarding this loan has to come through me. You probably heard, or we not probably did hear testimony from Mr. Olson yesterday, who was talking about how he's in a law firm and he turns around and he sends these notices saying, we're going to foreclose on your house. He does that for Wells Fargo. He does that for PNC. He's acting as your agent. He has the authority to do so, and that has legal ramifications. And just like that, Ms. Song hired me to send notice to say, hey, this is getting out of hand. You deal with an attorney. And I step in and I say, here I am, PNC. Any legal issues, any problems, come through me. That was in writing, and I'll show you a couple of those letters in a moment. No notice to Ms. Song. No notice to me. They foreclosed. This is that concept called proximate cause. We were talking about proximate cause, so they have that obligation. And I'll read this. I know everyone wants to read it. We can go through it together. There may be more than one proximate cause of an event, but if an act or omission of any person not a party to the suit was the sole proximate cause of an occurrence, then no act or omission of any party could have been a proximate cause. When I use the expression proximate cause, I mean a cause that in the natural or ordinary course of events produces the plaintiff's injury. It need not be the only cause, nor the last or nearest cause. It is sufficient if it combines with another cause resulting in injury. So I'll address some of those other lawsuits that they keep harping on in a second. But let's assume that they're correct. It was really the BB&T situation. You know, contrary to Jason, contrary to Faith's testimony, they were happy about it being resolved. That was the situation that has caused for all this angst. Let's say it was that dispute with one of the builder providing some building materials that was resolved. That's why she's been in depression for years and years and years. In order to accept the defendant's position, you would have to believe that the wrongful foreclosure had no impact on her, that it did not combine with anything else, that it was only those other issues that were the sole cause of her pain, of her hurt, of everything we're here for today. We went through all the testimony. We heard how we got to this position. We saw the confusion. We saw the stress. We saw the inconsistencies. We have PNC sending these letters. Some days are saying, pay us $16,000. The next day they're saying, pay us $11,000. Sometimes they're saying that if you're making partial payments, we'll return them. They never do. They say all sorts of inconsistent things. And when Mr. Bevins was here talking, he said something that I thought was interesting. He said, from the lender's perspective, this is what we do. Oh, yes, we say we're going to return these payments, but from a lender's perspective, no, we're going to keep them. How is an ordinary person supposed to figure out what's going on? And what can a diligent person do? They call the bank. They follow up. She's a businesswoman, but she solicits the support of her son. She says, you know what? My son speaks perfect English. He has a financial background. Let's get him involved. Let's see if we can get to the bottom of this. And what happens? They get bounced around like ping pong, back and forth, back and forth. There are no answers. They don't know. Is this stressful? Of course it is. And then finally, a breath of fresh air. After all this stress, after all this anxiety, she speaks with someone who says, you know what? I'm looking into this issue. And she does look into this issue. She keeps it on hold. And she says, I see it going from 2,700 to 5,500. That's unreasonable. Of course it's unreasonable. We're talking about $10,000 that PNC made in a tax payment. No doubt she should have done it. Once she found out that they did it, she said, I can reimburse you. She said, no, we're going to add it to your loan. That's fine. But then they come back and they say, we're not talking about an extra 10,000. We're talking about an extra 25,000. I think the exact figure we'll go through that is 22 something. How do you get this number? You even think about it, you say 10,000 times 2, 20,000. Where do we get this? And she's a businesswoman. She's smart. And if someone comes back and says, hey, we're going to start asking for more money, you say, why? Could you explain this? It's a significant sum. For PNC, it's nothing. But for an ordinary person, for a business person, it matters. And you want to find out, okay, I can pay this, but why? And she investigates. And then finally someone comes back and says, you know what? This is unreasonable. Starting February 1st, you heard her testimony. You're going to have to start making these payments of $3,800. And you heard that she was so happy that this thing's finally behind her, all the stress, that she actually mailed that payment off the very next day before she even got it. I will say this. We are extremely lucky that her son had the foresight to tell her to make a photocopy. If we did not have these documents, then PNC's position had been, they don't exist. PNC's position had been, what are you talking about? And at the very least, we know that once she started making her payments and she started calling PNC back, they were not able to confirm that this thing even happened. It wasn't until we got well into the lawsuit that they acquiesced that this thing actually occurred. The first thing I want to highlight about this is, we talked about it, there's an address change form. Because this case has happened so long ago, a lot of us may not remember, but when we had these physical coupon books, there used to be a page you could pull off and say, check here, this is my new address. She testified, she checked there, this is my new address. She submitted it. I heard something else that troubled me, where PNC's attorney just said that, well, how do we know that Ms. Zong didn't doctor this document? Let's look at the next page. And before we look at that, I just want you to see something that's proves she didn't doctor this document. Here's the information on the left, which is what you might expect from the first page of the coupon book. It says, here are some fees and so forth. Let's look at what the next page looks like. This is the next payment for March. The information on the next payment is different. And you can go through and see what she has, and you can see that for every single payment, aside for February 1st, it has that type of information on it. So when Ms. Ong ends up speaking with the representative, getting that breath of fresh air, and she receives this document, do you think it's reasonable for her to say, this is the amount I have to pay. And this is when it's due. So many things she's to come up with, and it reflects what you talked about. Should you be able to say, this is it, this is what we talked about, I'm going to send off the payment. When she sent off the payments, what was PNC's response? Did they ever come back and say, yes, you mailed this 3,800 payment, but you have to pay us more. We need more. And what really gets to me is the fact that they talked about how she was behind for 2 payments. Keep in mind, she made December at her prior amount of 2,700 or so. She made January at her prior amount of roughly 2,700 or so. And then she came back and she reached an agreement with PNC. So if we're talking about the difference between her new payments and her past ones that she's been making, we're talking about $1,000. So according to PNC, she didn't make she was $1,000 short in December, and she was $1,000 short in January. Do you think for a moment that PNC would have come back and said, you owe us December or January, you owe us this delta, you owe us, let's just say full 3,600. Do you think for a moment she wouldn't have said, okay? Instead, what happens? She gets this letter. And what does it say? Payment doesn't meet current exceptions guidelines. What does that mean? What guidelines? I don't see guidelines on here. What am I supposed to do? If you're a reasonable person, and that's why you're all on the jury, because you're all reasonable people, what do? What should you do? You call PNC. You say, why? But she calls PNC. And they're like, what are you talking about? What do you mean 3,800? What 3,800 are you talking about? We never agreed to accept that amount. She sends another payment. They return it back to her. What does it say? Payment doesn't meet current acceptance guidelines. Does this sound like someone who's been communicated to by PNC saying you owe us a certain amount? Or does this sound like someone who's trying to figure out this mess, who's trying to say, hey, PNC, here are my coupons. I'm doing what you told me to do. Why aren't you accepting them? She calls PNC every single time. She calls them and says, why don't they meet acceptance guidelines? And they cannot provide her a straight answer. And we've all experienced how this goes. We call your cable company, they can't answer exactly what's going on and they bounce you off. As Mr. Tobin mentioned, there's a lot of people working there. It's easy to pass the buck. And I don't blame those individuals, but I do blame PNC. They can't give her an answer. Is that reasonable? Should Ms. Zong have expected that when she sends these payments like they told her to, they'd accept them? Is it fair that they can't tell her why? One of the things that PNC wasn't able to explain. When Ms. Zong came back and said that we want the payoff amount, how did they do this? On the next page, we're going to look at the escrow disclosure statement. Look at this. They're saying in July, she's passed due in 8 payments of the $3,891. That's assuming that she had to pay the $3,891 in December and January. Let's go with that assumption. Yes, it's different from what it probably said. Yes, it's different than what we told you we have to pay you. But let's go with that assumption. Remember that Ms. Zong's escrow payments increased from 2,700 to 5,500. For mortgage payments increased by that amount. Why? Because they said that there's an escrow deficiency, there's an escrow shortage. And then sometime later, after speaking with that helpful representative, they said, this is unreasonable. We're going to take this shortage and we're going to spread it out over not 12 months, but 5 years. That was supposed to resolve the escrow shortage. Yet here we are in July. This is a few months after that discussion in January 27th. And here they are, we're asking for the payoff amount, saying, all right, let's see what we can do. Let's see what we can figure out how we can resolve the situation. And they're coming back and they're adding a $16,207.35 in an escrow shortage. We just resolved the escrow shortage. How are we dealing with another 16,000? What about all these other things? Why are we being charged $400 in late charges when we just made those payments that you told us to do with the coupon book? I still don't know what a corporate advance is. The BPO, I don't know. But here we are. We're talking about a $31,000 payment. They're saying you owe us $31,000. This is how much you owe us. And they're tacking on another $20,000 with fees, with advances, with all of this other stuff that doesn't make sense. And perhaps the biggest one that doesn't make sense is this escrow shortage. We resolved the escrow shortage. How are you charging us for escrow shortage again? We can't get any answers. So what does Ms. Zong do? And what has she been told to do since day one? Every time she calls in, and you can see these in these call logs, PNC always says, let's do a workout, let's do a hardship. I don't know why they've been pushing for that since day one. They have been. And they always say, we need you to do this hardship application so you go to someone who can figure out what's going on. And so that's what she does. But you don't have to take my word about this escrow shortage. I'm gonna look at the next page. I apologize because it's small. But it mentions, this discusses the escrow and prorated escrow. This is her prior principal and interest of the 2,700. This is your new payment of the 3,891. And on the very next page of that document, it mentions that they're going to spread that escrow shortage out over 60 months, over 5 years. And this is dated January 27th. So here we are, where Ms. Zong missed roughly $10,000 in her tax payment, and PNC said, we'll pay it for you. They can do that, that's fine. And then PNC comes back and says, we're going to increase your monthly payment. And then later they come back and say, well, that was too high. Someone nice actually looks into it and says, your new monthly payment is going to be 3,800. But we're jumping up from 2,700 to 3,800. We're talking about roughly $1,000 over 5 years. That is $60,000. We're talking about an increase of $60,000 that's going onto our loan per prior page. And they're saying that's how much you have to pay for missing that 10,000. And then we're asking for the payoff. Here we are in July, or not the payoff, the reinstatement, excuse me. We're saying, here we are in July. How do we get out of this mess? And they're saying, not only do you have to keep paying this amount for the 5 years, it's $60,000 for missing that $10,000 payment, but now you have to do an extra approximately $20,000. Talking about $80,000 for PNC paying a $10,000 tax payment. They've never been able to explain this. They can come in here and say all sorts of reasons why you're doing it. Doesn't make sense. And most importantly, Mr. Bevins was talking and he was explaining, well, from the lender's perspective, this is what we do. Oh, yes, there's a late charge. We don't tell you about that, but this is how we assess it. Miss Song didn't have the benefit of Mr. Bevins sitting next to her. She had her son, she had her husband. When they were trying to figure out what's going on, she's hitting a dead end. I'm an attorney and I can't figure out how they came up with these numbers. They don't make sense. They've never made sense. And Ms. Zong has always been adamant that, all right, get this to someone who can figure out what's going on. We'll do the hardship application. You tell us that's how it's going to go to someone who can look into this. We will do it. And of course, she's not going to come back and say, I can pay this or whatever, because then they're not going to look into it. So she submits her information, says that, please get this to someone who can help. They keep asking for the same information over and over and over. Please send us this, please send us that. She does it. She never gets a proper response. And she keeps doing that until we get to what ultimately happens to be for foreclosure. We mentioned that she made 4 payments to PNC after she got off the phone with that rep. The very next day, she sent off a payment for $3,800 without the coupon. She turned around, she made another payment for the $3,800. Got sent back to her, insufficient funds, not insufficient funds. Doesn't meet payment guidelines. PNC doesn't explain what it is. PNC doesn't explain how they came up with it, doesn't meet payment guidelines. She does another one, she gets a letter back. She sends the 4th one, and this is what she gets. Your loan has defaulted, payment less than total due, repayment plan has defaulted. We saw the phone log, the email log from that law firm that actually looked into the situation, that was doing the foreclosure for PNC. And we saw an email that she sent to the law firm saying, how did you get this? What is this number? And their response was, you need to ask PNC. And that's when she pulled me into the mix and said, this is getting legal. This is getting out of hand. And I need to escalate the situation on my side. She pulls me in. At this point in time, once I get pulled in, there's a few things that happen. There's a few letters that are sent. There's numerous where I direct PNC that any disputes, any matters, any questions or issues regarding this foreclosure, or regarding this property, or regarding Ms. Song, comes to me. She does what a reasonable person would do, what a diligent person would do. She hires an attorney. She said, I want the attorney to figure out what's going on. And I send multiple letters, and you can see them when you're back there. And what happens? I get the same response as in the song. No response. do a hardship application. What's the response to that? Okay, we'll do it. You mentioned that Ms. Zong updated her address. And here is one of the later correspondence. There's other correspondence, but here's one of the later ones that PNC sent Ms. Zong on, look at this date, January 31st, 2012. The foreclosure happened in March of 2012. So they send her this letter. It has the old Alabama address. One of the things Ms. Zong said is that old Alabama is very long. If you're just mailing off the letter to, P.O. Box 289 in old Alabama, then it may get to you, it may not, but that's not the proper address. It needs 3000 Old Alabama Road. And so here we are on January 31st, 2012. And they're saying, we haven't received your hazard insurance. And so what is Ms. Zong's response? She gets information. She sends it to PNC. And PNC receives it sometime between then and between February 16th. They send her this letter acknowledging it, saying, okay, we got your hazard insurance. Thank you. Coverage amount, 700,000. Effective date, January 28th, 2012. As soon as she gets a letter, she gets the hazard insurance with an effective date of January 28th, 2012 for the property. And then she sends it off to them. And they say, okay, we got it, thank you. And they mail the confirmation to her proper address. At this point, PNC knew the property was vacant. You heard Ms. Zong's testimony that the tenants, the doctors, or the doctor and her husband, who were good people, got tired of people from the bank knocking on the door and leaving. They left. PNC knows at this point in time that the property is vacant. August 1st, 2011, they sent her a letter, property is vacant. They know it. There's no question about it. This is their letter. They're aware that no one lives there. Mr. Olson testified to when PNC, on behalf of Wells Fargo, foreclosed on base property, that they sent notice to only 2 addresses. The most important one is that post office box of 289. It doesn't have a street address. And I'll zoom in on the next screen so we can actually see it. This is the certified letter that he sent. It's missing the street address. Missing the old Alabama road, where all of these other letters that we're sending were being sent to. Something else that wasn't on there was any notification or any sort of record showing that they sent the notice to me. Just like I'm Ms. Zong's attorney and I can send letters on her behalf, so too could Mr. Olson and his law firm send letters on behalf of PNC and Wells Fargo. And that's what he did, and that's his goal. just like my role is to represent this song and to be her attorney. This is the notification they sent, the notice of foreclosure sale. Once again, what do we see here in terms of the creditor? If you remember, the law said that there's two requirements. The secured creditor has to send a notice, and it has to be sent at the address denoted by the borrower in writing. Creditor on this one is Wells Fargo Bank, NA GSR 2004-12. I think it's safe to assume that it's Wells Fargo Bank. This is not a typo. We'll discuss that in a moment. But we go through the letter and we see Wells Fargo mentioned numerous times. This wasn't a one-off typo. This is fraud. See that same language throughout this notice saying that we're going to take your property that Ms. Song never got, that I never got, saying that Wells Fargo Bank GSR 2012, GSR 2004-12 is going to take your property. And then the bottom, it says, yes, Faye, Wells Fargo is acting on your behalf. Wells Fargo NAGSR is acting on your behalf. Attorney, in fact, for Faye Song. Yesterday, we heard from Peter Favorite, who was here on behalf of Wells Fargo. And he was like, I looked into the situation and I questioned him about his affidavit. And we went through some very important lines together. According to Mr. Favorite, to my knowledge, no entity known as Wells Fargo Bank NA GSR exists. On March 6th, 2012, PNC, again, without the knowledge or consent of Wells Fargo, and purportedly, as this agent and attorney in fact, foreclosed on the subject property in the name of Wells Fargo. I have reviewed the records of Wells Fargo, and I have been unable to locate a power of attorney that granted PNC the power to conduct this foreclosure in the name of Wells Fargo. Wells Fargo's own vice president came in here and said, there's no such thing as Wells Fargo NAGSR. There's nothing that gave PNC the authority to foreclose in our name.
Your Honor, we would object to use this particular demonstrative. This is not an evidence.
You know what? I don't need to use this one.
Let's take it down or move to the next slide.
Sure. One thing that you heard Faye say was that every time she called PNC, what's the first thing you hear when you call any of these companies? This call is being recorded for quality assurance, training purposes, for the call is being recorded for some reason. We got into this lawsuit. We asked PNC. Give us these recordings. Give us this information. This is what my client says has happened. That would be best evidence of these conversations. That would be the best records of what happened. The actual agent in Ms. Long's conversation. What was PNC's response to that? That's not in this letter. That was in a prior exhibit that I just pulled down. But what I will do is I will read to you, just like I read to Mr. Bevins, our conversation.
How we would object to this because it's not in evidence.
I think that's accurate.
It doesn't have to be in evidence, Your Honor. This was his testimony. It wasn't evidence.
Then you can refer to his testimony, but you should not read from an exhibit that wasn't tendered.
And I'm sorry I have to do this, ladies and gentlemen, but I made specific notes of the testimony because I thought it was important. And it's going to take me a moment to just pull it up. But I think it goes through everything that my client was going through. And I want you to hear this. While my colleague finds it, I'm going to resume. And I'll read to you the exact language if you're interested. But essentially, when PNC was up there, I asked, do you keep the recordings? And did you hear what the representative said? I actually pulled out the transcript from the folder because we questioned them under oath previously and said, let's go to what was previously discussed. And I said, do you keep the recordings? And they're like, usually not. And I said, well, what if someone tells you that there's a possibility of going into a lawsuit, there's a possibility of litigation?
No, I'm sorry, I have to register an objection here. This was addressed. I think Mr. Adair is going beyond what is appropriate under the limitations that we've been provided.
All right, members of the jury, I'll instruct you that you're to base your verdict only upon the evidence as you remember it, and base your verdict solely on that evidence. The arguments of counsel, of all counsel, are not evidence. Mr. Adair, you can proceed.
Just to be clear, Your Honor, was my objection overruled?
I have responded to your objection as noted for the record.
We asked PNC, what if there's a possibility of litigation? You still keep it? What was the response? We don't have a crystal ball. We don't know if litigation is going to happen.
Objection, Your Honor. That's precisely what is not in evidence.
Your Honor,
All right. Overruled. Jury will recall my previous instruction.
Aaron, why you don't want you to hear this?
That's inappropriate, Mr. Haydary. The jury will disregard that entirely in their deliberations.
So we asked them, what if you think that there's a possibility of litigation? They say, we don't have a crystal ball, we can't foresee the future. And I asked them, I'm like, what if someone tells you you're going to sue? They said, it doesn't matter. We said, why not? The response, I don't mean to be flippant, but people say a lot of things. Until it actually happens, doesn't mean it happens. Does it matter if it's an attorney or if it's a homeowner? And they say no. So here we are in the middle of a dispute. You know something's going on. And what happened to those audio recordings? They got zapped. The song comes back and says, you guys told me to make these payments. They say, we don't have any proof of them. The song says, give me a copy of your coupon book. Show me that I want some documentation reflecting what we agreed upon. It doesn't exist. It's not until she comes into this lawsuit that they acknowledge it later, where she says, look, I got copies. And try to come up with an explanation to justify why they weren't accepting. One of those letters I referenced earlier, where we mentioned that you need to give us notice. This is it right here. There are several of these. They all say the same thing. My law firm represents Ms. Zong. Please return all future correspondence regarding this matter to me. That's a phone number and has a property address. We know they got this. There's no dispute about that. There's no dispute that they did correspond with me. There's no dispute that when they decided to cancel the prior foreclosure, they provided me notice.
One letter that I think is indicative of what was taking place is the following one.
This was in June of 2011. And I mentioned to them, in an effort to amicably resolve this dispute, your representative stated that Ms. Zong should complete a hardship mortgage application. Although Ms. Zong was not requesting any sort of a mortgage modification, and in parentheses I said, and instead simply wanted PNC to abide by its previous agreement, she has subsequently submitted the requested documents on numerous separate occasions in a gesture of good faith. Despite doing everything requested, Ms. Zong has still gotten no response about this situation. My client is simply asking for PNC to abide by the agreement it made early this year. Nothing more. And we don't get a response to this either. We continue submitting information. We continue submitting what they're asking for. They say, do this, do that. Ms. Zong does it. She updates her information. Or has her insurance. She provides it to them. Nothing else happens after that. What happens is they close on her property without telling her, without telling me. Brief summary of the situation, and then I want to address a few points and then get what I'm asking you guys. It's that they didn't provide notice to her. They didn't provide notice to me. When they foreclosed on behalf of what they now claim was a non-existent. Each of those are separate grounds for a wrongful foreclosure. We just need one. The other component is that told Ms. Zong do something. And she did it. She believed them. They didn't honor. Mr. Tobin, when he was making closing arguments, mentioned that, or insinuated that this was just an investment property. She didn't really care about it. I mean, maybe she did, but this was an investment. We heard the testimony. This would not have made sense for an investment. This was something that she put a lot of thought, care, and heart into. This is something that she put her family's consideration into. It was on a difficult property. It wouldn't have made sense to be an investment. It wouldn't have made sense for her to buy that and build it out for someone else. That was her dream. And we also heard testimony from her son and from her that there were multiple dreams. She dreamed to come over from China to have a better life for her son. She dreamed that she was going to be able to start her own business and do what she did. At some point in time, she thought that I can make my next dream come true. I can build my dream home. And that's what she did. She built that dream home. And it was magnificent, and she was happy with it. The other side says that, you know what, she made out from this deal. She made out from this arrangement because she took out a $600,000 loan and she got $100,000 cash back. Why doesn't it make sense for that to be a viable investment? You all know that when you buy a property, you have to put 20% down. Bank is never going to say, you know what, we're going to give you this loan for this property 100%. We talked about Ms. Zong, she ended up buying this home for $860,000. That was a lot of money. That is a lot of money. That is an American dream. This was back in 2004 in Sandy Springs. We all know what Sandy Springs is like. It's a beautiful area. You heard the realtor talking about that. Described it as a petal on the sunflower. She achieved that dream. She made it come true for herself and for her family. In this situation,
Mr. Tobin also mentioned a few other points that I want to address.
which is, he mentioned that, you know what? She had difficulties with her other businesses. This was a housing market crisis. Yeah, real estate went down, there's no question about that. But in that situation, what happened whenever there was an issue? Zong took care of it. What did she do? She came to me. And in two other business issues that they mentioned, she resolved them. Ms. Zong talked about how in this situation, there's a big difference between personal and business. Business comes and goes. I can start a new company tomorrow. I can start a new law firm. Ms. Zong can do the same. It happens. Sometimes you make good business decisions, sometimes they don't work out. But personal is personal. The business venture doesn't work out, okay. But where does the personal come in? When you make something for yourself, when you make something for your kids, with love. This whole time, GNC has been attacking Ms. Zong. I question whether or not there's not a single person in this room who has things that happen that are unfortunate, that are not ideal. Things happen. And in this situation, PNC has not accepted a single ounce of responsibility for anything. It baffles me that they can come in here and say that she hasn't been hurt by this foreclosure. But she hasn't been harmed from this situation. How can you make that argument with a straight face? There was something that I specifically quoted and Mr. Tobin said.
It was all what you expect from the bank? Is this what Ms. Zong should expect from the bank? Is this what we should expect from the banks? When you have these sort of disputes and you reach out to them, you ask for help, and you say, I don't understand, is this what we should expect? That they're gonna confuse us, that they're gonna tell us to do something and then turn around and take our home? Early on, in this case, I asked all of you what your home means to you. And we all had different answers. It's a deeply personal question. There's no right or wrong. But one thing we can all agree on is that it's our home. And just because there's someone else out there who says that, you know, you're having a business dispute or anything else, doesn't mean that someone can come and take your home. This was her dream. And the other side has come back and said that, well, you know what? We saw that maybe she wanted to move out. Maybe she did this. Maybe she did that. That's her choice. She moved halfway across the world to give her son a better life. She wanted to pursue something to make him have a better life, and she flew from China to California with a young boy. That's hard. That takes dedication. That takes bravery. She followed her sister to Atlanta. It's obvious that family is very important to her. Do you think that for a minute, Ms. Zong wouldn't move 30 minutes away because she wants to give her daughter a better life and pursue or have her pursue art in a certain school? Of course she would. The other side tries to point, this is evidence that she didn't care about her home. It's evidence that she cared about her family. It's evidence that she was willing to do anything for her children. We all know the sacrifices we make for our children. We all know what we're willing to do for them. And for the other side to insinuate that because she moved to let her daughter go to art school means that they can take her home, that she wasn't hurt, that she didn't really care, it's insulting. It's mean. It's malicious. This lady, Ms. Zong, they moved halfway across the world to bring a better life, chase her dream. She had achieved that. She was an embodiment of the American dream. We all chase our dreams. And we can, and we should always continue to chase our dreams. And she tried to do what's better for herself and for her children. Yeah. And what do you think happened after the foreclosure? After they didn't give notice to her, and then after they didn't give notice to me? She tried to shield her children. She tried to protect them. Where do you think all that stress went? And she has her young girl. And her girl wants to know when they're moving back home because now her art program is done. Where do you think that stress goes? How do you think Ms. Zong responds? By trying to protect them. That's what mothers do. They protect their children. And all that stress, it comes in. It gets internalized. And you can't let it out. You don't want to let it out because you don't want to hurt your children. You don't want to burden your children. You heard her niece say, where does she live now? She lives with her son. She feels like she's a burden to her son. She's not a burden, but that's how she feels. She was in a certain trajectory. She was in the top of her game. She built her home, and that was what she wanted to do. And that's what she achieved. And they took it from her. And the worst part is, they didn't even tell her. Once we found out that they foreclosed, the lawsuit was filed the next day. We heard testimony that the banks were served the next day. Do you think for a minute that if Ms. Song had gotten notice of the lawsuit, she would have just sat back, or excuse me, notice of the foreclosure, she would have just sat back and said, you know what? Despite the fact that I did what you told me, despite the fact that we have all these questions, despite the fact that none of this makes any sense, despite the fact that Wells Fargo has no interest, we're just going to sit back and do nothing. At that point, she had me. She had my firm, and we were supposed to be her shield. We were supposed to protect her from this. And we told PNC that as her attorney, if anything happens, it has to come through us. And we had protected her in the past in business issues, but those are business. But this was a personal issue, and we told them, if you have any issues, you come through us. Once we found out, we sued them. And we said, you made all these mistakes. We didn't accept the payments. We foreclosed in our name of the wrong party. They didn't give us notice. We want our property back. And what was PNC's response? No, 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 no. Even worse than that. What did they do? They turned around, they transferred it. We told them, you guys screwed up, you guys made a mistake. And they took it and they transferred it away, so she'll never get it back. We told her, hey, you guys made this mistake. Fix it, help us fix it. Look at this. That's malicious. That was on purpose. Is this what we expect the bank to do? Is this what we as a society can expect the banks to rely on to do? Does that make sense? Is this how we hope that they respond? And then when all this is said and done, once we notice you can never get our property back, saying, hey, oh yes, this was a made-up entity. Oh yes, I see here that we were sending notices to this address, but you know what? We knew it was vacant. We didn't have to send it to you anyways. Is that acceptable for society? Is that acceptable for Ms. Long? She testified not through her own testimony. She did not want to come in here and talk about what she experienced, what she felt. She didn't want her daughter to testify because she didn't want her to put her through stress. That's the mother's burden. That's what parents do for children. But you heard from the people around her what she experienced. You heard her pain. You heard how she isolated herself. You heard how she's never been the same since. This has been a 12-year-long journey for Ms. Song. 12 years. PNC says, well, if we would have told you about it, there's nothing you could have done. We've been fighting this for 12 years. Do you honestly think for a minute that we wouldn't have stopped it if we had known? Do you honestly think that we wouldn't have saved her dream? The audacity for them to come back and say, well, she moved. She wanted a different dream. That's her choice. She can always chase other dreams. But they broke her. And they did so on purpose. And they did so after we told them. Even today, when they come in here, they don't accept any responsibility. I did not hear once them saying, we should have done this. It's all excuses. It's all excuses. for Ms. Zong, that was her dream. For them, I'd say it's like pocket change in their pocket, but it's not even pocket change. It's lint in their pocket. It's another mark on the balance sheet. What do you think the value of Ms. Zong's home is today?
Objection, Your Honor. That's-
We'll see where it goes with it. Overruled.
Where do you think she would be? PNC didn't take her home. Wells Fargo didn't take her home. She wants to get back in there. What is it going to take to make her whole? We're asking from you, ladies and gentlemen, to make her whole. You're the only ones who can make this right. We don't have a time machine. She wants her home back. You can't get that time machine to go back in time. The only thing we can do is try to fix the situation as best as we can. That's where you come in, and you have the power to weigh those scales of justice. And think about what was promised to her, what she relied on, where she should be in her home. Mr. Tobin was talking about this is Labor Day weekend. She should be going back to her home in Latour. Going back to her son's house. You heard her about her trajectory, where she was going. She was at the top of her game. She was doing the best. But this crushed her, as it would. She had the keys to her kingdom until those banks changed the locks. And for them to say that they have no responsibility, that she wasn't harmed, it's not just bad faith, it's insulting. She didn't want to have to hire me. She just wanted them to do what they said they would do. We're going to ask you to make her whole. And just to tell you what the jury verdict form is going to look like. There's going to be a number of places in that verdict form. It's going to ask for nominal damages. For every single place that it requests nominal damage, we ask that you award $1. For every place that they ask for compensatory damages, we're going to ask that you award $0. And for every place that they ask for general damages, we're going to ask that you award the following sums. For the promissory estoppel, for the breaking of the promise, we're going to ask that you award $3 million. How much would it take to get her back in there? She's never going to get back in there. But if we want to try to fix this, that's what we want. Make her whole. For the wrongful foreclosure, once again, we're going to ask for $0 for compensatory. But for the general damages, we're going to ask that you award $3 million against PNC.
I have to register an objection here. Perhaps we should be ready at the bench.
You can approach.
Can we take a restroom break real quick?
Please.
Stay quiet. Sorry.
No. Stop. Who did that for us?
Close the door. There. All right, just let me know when they're done. All right, first thing, jury has stepped out. Well, let me do one thing first. I want to complete the record. We had a bench conference at the conclusion of Mr. Howard's closing argument where Mr. Haderi noted his objection and believed Mr. Howard's argument was veering into
Causality.
liability essentially. And assuming that those arguments aren't waived because they weren't raised contemporaneously at the time of the argument, overruled them, finding that I don't think he had crossed into that in his argument. And even if they had been raised contemporaneously, I don't think I would have granted them. So is there anything else you want to put on the record as it relates to that?
No, Your Honor, but once again, we're contesting liability. That's all.
Understood. All right. And now we have jury requesting a break and an objection by Mr. Tobin.
Your Honor, the objection was to this request for $3 million in general damages. You've been talking about a verdict form. There was never any discussion of a general damage part. And $3 million is obviously like an excessive, a way excessive punitive figure. So the question that the jury should be allowed to consider that request is outside the scope of this case. It would be, I think, clearly reversible if that limiting instruction is not given on that point. And two, I think the jury also needs a limiting instruction that conduct after the litigation starts is not pertinent to the finding of that fee. Mr. Haderi was clearly trying to apply. So without those instructions.
So taking those in reverse order, the bad faith, I haven't seen argument getting explicitly there. I think it's in the instructions for them. And I think that that was something that could be highlighted and I think in fact was during the defense argument. So I don't think we've gotten to that point where I need to correct them there. On the amount of the 3 million, that's the first time we've heard that, but I don't, because there is no anchoring point in the instructions or in the law. It's just supposed to be enlightened conscience. I don't see that being a point of law that requires an instruction or requires the court to step in and say, what is too much of an ask? But on the point of where he's categorizing that as general damages, I do think there's something there, and it raised an eyebrow on my end. Yes, I see it came through on the latest proposed verdict form, but that hasn't something we've locked in. And
Was that during the argument?
that's right. And I wasn't actually planning, and I was going to discuss that at the conclusion of this, is I didn't think that that was going to be the breakdown we were going to go with. When I'm looking at the definition of, general damages versus compensatory damages versus nominal damages, I see compensatory as being the umbrella that holds general and holds all these other things in. So all I was planning to do on this verdict form was to break it down to nominal and compensatory. And then later, if and when we get to that point, there would be the attorney's fees and punitive. So this term of general being used, that kind of just came up out of nowhere. It hadn't come up in any of our discussions yet. So maybe you want to clarify that when you'll have a chance to here when you come back. But as of now, the intention was the verdict form would just be breaking it down by nominal and compensatory.
Exactly what we should discuss. And I think unless the jury is given clear instruction that Mr. Haderi's 0 and 1, I think he probably needs to revise that.
I mean, he could just do that in his argument. And I'll also note it's because in our charge, we don't even define general damages anymore. I don't think it's even in here. We just talk about what nominal is. We talk about what mental anguish and that sort of thing is. But the term general damages isn't even defined in here.
That was,
Take a limiting instruction telling the jury that concept of general damages and the figure $3 million has to be banished from their consideration.
Well, I mean, I've already told you that I think the 3 million is something he's just allowed to come up with any figure he wants. So in terms of where it,
Objection on the record.
Yeah.
I mean, it's got to be grounded in the evidence. I mean, the jury's not supposed to
Yeah.
just sort of say $50 million. I mean, there's a $250,000 punitive cap for this. But general damages is just like whatever they want.
that's how I read the instructions, and I think that that mental anguish is something that there isn't that kind of cap on. So it's certainly noted, and that's again why we are trying to delineate these different forms of damages. So, Mr. Haderi, anything you want to address there?
no, must have been my confusion. I thought we were going to have 3 lines. My preference was to have 1 line for all of them.
Right.
And so that's why I was trying to sort of elucidate what our verdict form might look like. And so that's just the point of misunderstanding. But if the court believes that we're going to put general under an umbrella of compensatory, that's fine.
That's just how I'm seeing it. General damages are defined as a type of compensatory damages, and I'm looking at OCGA 51-12-2, which defines general damages. And I know that these terms always just get kind of intermingled there, so I recognize the ambiguity. But the only terms I'm really going off are charge, and the only thing that's defined in the charge is nominal, and then kind of everything else.
If I can be heard briefly, Your Honor, 2 points. One, I think the Court of Appeals decision very clearly delineated the sort of damages that Mr. Haidari is allowed to seek. And I don't think a general demand for $3 million, and I guess he hasn't made a general demand for $3 million since Wells Fargo yet. But I'd like to lodge an objection, assuming he is. Jump up and object. I don't want to waive it. I don't want to stop the closing argument immediately as soon as it starts talking. I'm going to lodge that objection for the record as well.
Okay, anything you want to address on that point, Mr. Haidari? I mean, look, if y'all have law on it, I always love to read case law, and I'd love to see some precedent that's saying that there has to be some kind of anchoring to a compensatory damage ask, just the ask itself.
General damages, it's not, it wasn't raised until apparently a draft verdict from came out during closing.
And I think we've already he's conceded that. And so if instead he's now going to pivot and say, for the compensatory damages, because of this mental anguish, or even because of the breach of the promise, I want you to award $3 million. Do you have something that says he's not allowed?
I would say
To put it-
back to the Court of Appeals decision in this case, Your Honor, that I think did go into some detail about what he claimed and what he cannot.
Any particular portion of it?
I don't in my hands, Your Honor. I apologize.
Okay, he's right
I
there.
think we made our objection for the record that these numbers have to be grounded in the evidence and the law. So there's certain objection on that basis.
Okay,
Just the only point is that this is the enlightened, conscious, and impartial jury, and they get to hear everything and decide whatever they want to decide, and we can make the request. There's absolutely no limitation. That's the whole purpose of having a jury, Your Honor.
all right. You understand the distinction though between compensatory and nominal and how that's delineated, but nothing else is?
I do now, Your Honor. I apologize for the confusion.
You don't have to apologize to me. You just have to clean it up with the jury.
I will.
All right.
I'm just going to ask, what is the purpose between breaking down a nominal and,
It's more, the difference is because nominal is also something they could award. There's no cap or anything.
correct?
You've told them to only do $1, but they could do something more.
Sure.
And because the law that applies to both of those is very different in terms of what the finding has to be, I think those need to be separately shown. That was the thinking. Anything else?
May I use the restroom for a few minutes?
All right, please make it quick.
Thank you.
How do you do it day to day like that?
We don't have to do this every day. The restroom request. Oh, wait.
Excuse me.
All right, ready? All right, let's go back on the record. Mr. Haydari, just I'll note, I'm not planning to interrupt you, but I'm still keeping time, so
I'm towards the end.
I'm sorry.
I'm almost done.
I'm just whatever you want to choose. That's your time. I just wanted to make you aware of it. Anything else we need to take up before we bring back the jury for you to continue?
Our proposed verdict forms for meetings up with the suit. And we sent them. Plaintiffs' counsel as well.
Okay, but these still aren't joint requests. You're just both sending whatever you want. Okay. All right, if we could bring back the jury.
No. No, I forgot.
Thank you, Deputy Scott. Mr. Dare, when you're ready, continue.
So I need to clarify something. My mistake. Change focus. So a moment ago, I asked you to do $1 nominal damages. That's what I requested. On its own, anytime you see nominal damages, put one there. And a second ago, I said, put 0 for compensatory. Please strike that out. We're now putting general under compensatory. So for compensatory, honestly, pocket, we're gonna ask you to award her $3 million. And for the wrongful foreclosure against PNC for compensatory, we're gonna ask you to award her $3 million. And for the wrongful foreclosure against Wells Fargo, we're going to ask compensatory to award her $3 million. That's our request. We appreciate it. But please know that as a jury, you have the power to do whatever you think is fair. You heard how this has impacted her, what this has done. If you'd like to go higher, we'd be happy. I know this has been a long week. It's been a longer 12 years for my client. It's been a long path. You all are the only ones who have the power to make right. You're arbiters of justice. You have the ability to wrong, to fix what has been wrong. You have the ability to put her where she should have been. Appreciate it. Thank you very much.
All right, members of the jury, now that closing arguments have concluded, it's my job to charge you on the law that applies to this case. This process takes about 15 to 20 minutes, and you'll be provided a copy of these charges during your deliberations. You have been considering the case of Fei Zong, the plaintiff, versus PNC Bank and Wells Fargo Bank as the defendants in this civil action 2012 CV 215383. Plaintiff Zong filed this action here in the Superior Court of Fulton County, in which she brings claims against the defendants for wrongful foreclosure and promissory estoppel. The plaintiff must prove every essential element of her claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that the plaintiff's claim is more likely true than not true. If proof fails to establish any essential part of a claim by a preponderance of the evidence, you must find against the plaintiff. When more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of the plaintiff's claims by a preponderance of the evidence, you must find for the defendant as to that claim. Evidence is the means by which any fact is put in question and is established or disproved. Evidence includes all of the testimony of the witnesses, as well as the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is evidence that immediately points to the question at issue. Circumstantial evidence is evidence that only tends to establish a fact. It must be such as to reasonably establish that fact rather than anything else. The comparative weight of circumstantial and direct evidence on any given issue is a question of fact for you to decide. Sometimes evidence is admitted for a limited purpose or against some parties and not others. Such evidence may be considered by the jury for the sole issue or purpose against that party for which the evidence is limited and not for any other purpose. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Principals shall be bound for the care and loyalty of their agent in their business, and shall be bound for the neglect and fraud of their agent in the transaction of such business. The first claim before you involves a claim for the tort of wrongful foreclosure. The elements of wrongful foreclosure that must be proven against PNC by a preponderance of the evidence are as follows. 1, that PNC owed a legal duty to the plaintiff. 2, that PNC breached that duty. And 3, PNC's breach was the proximate cause of the plaintiff's injuries. And 4, plaintiff's injuries resulted in damages. Wells Fargo is in default, which means that the plaintiff has satisfied the first 3 of those requirements as to Wells Fargo. However, the assessment of liability against Wells Fargo does not affect PNC. Plaintiff asserts that the defendants owed and breached a duty to the plaintiff to provide proper notice of the foreclosure sale in compliance with the applicable Georgia statute, OCGA 44-14-162.2. Under this statute, notice of the initiation of proceedings to exercise a power of sale on a mortgage, security deed, or other lien contract shall be given to the debtor by the secured creditor no later than 30 days before the date of the proposed foreclosure. Such notice shall be in writing, shall include the name, address, and telephone number of the individual or entity who shall have full authority to negotiate, amend, and modify all terms of the mortgage with the debtor, and shall be sent by registered or certified mail or statutory overnight delivery, return receipt requested, to the property address, or to such other address as the debtor may designate by written notice to the secured creditor. The duty under the statute is satisfied once the foreclosing party properly mails the notice of the foreclosure sale to the debtor. The secured debtor must send notice to the property address unless the debtor designates in writing another address. Whether the debtor actually receives this notice is immaterial. If plaintiff establishes a breach of OCGA 44-14-162.2, she must further show that the defective notice was the proximate cause of the plaintiff's injury. Proximate cause means that cause which, in a natural and continuous sequence, produces an event, and without which cause such event would not have occurred. In order to be a proximate cause, the act or admission complained of must be such that a person using ordinary care would have foreseen that the event, or some similar event, might reasonably result therefrom. There may be more than one proximate cause of an event, but if an act or omission of any party, not a party to the suit, was the sole proximate cause of an occurrence, then no act or omission of any party could have been a proximate cause. When I use the expression proximate cause, I mean a cause that, in the natural and ordinary course of events, produced the plaintiff's injury. It need not be the only cause, nor the latest or nearest cause. It is sufficient if it combines with another cause resulting in the injury. To establish her claim for wrongful foreclosure against PNC, the plaintiff must carry her burden of proof by a preponderance of the evidence as to each of the 4 elements of her claim. As I have instructed you, Wells Fargo's default status means that the plaintiff has established the elements of her claim against Wells Fargo. However, as to Wells Fargo, the plaintiff must also establish the amount of any money damages, if any, that she suffered as a result of the conduct for which Wells Fargo has been deemed liable. I will later provide you with separate instructions regarding damages. The second claim before you is one for promissory estoppel. Georgia law allows certain plaintiffs to pursue claims based on promises that do not rise to the level of being enforceable contracts. The plaintiff has not alleged a promissory estoppel claim against Wells Fargo. To prevail on her promissory estoppel claim against PNC, the plaintiff must establish each of the following elements by a preponderance of the evidence. 1, the PNC made a promise or promises. 2, PNC should have reasonably expected plaintiff to rely on such a promise. 3, plaintiff relied on that promise to her detriment. And 4, an injustice can only be avoided by the enforcement of the promise because, as a result of the reliance, plaintiff changed her position to her detriment by surrendering, foregoing, or rendering a valuable right. For purposes of plaintiff's promissory estoppel claim against PNC, the definition of promise is a manifestation of an intention to act or refrain from acting in a specified way, so made as to justify the recipient of the promise in understanding that a commitment has been made. For a promise to be enforceable in a claim for promissory estoppel, the alleged promise cannot be vague or indefinite. Instead, the promise must be clear and specific as to exactly what is being promised, including as to the length of time the promise will be in effect. If you find that PNC made a promise to plaintiff that satisfies the requirements I provided you, you must next determine whether PNC should reasonably have expected plaintiff to rely to her detriment on such promise. If you conclude that PNC should reasonably have expected plaintiff to rely on the promise, then you must determine whether plaintiff in fact reasonably relied on the promise. Damages are given as pay or compensation for injury done. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe from a preponderance of the evidence that the plaintiff is entitled to recover, you should award to the plaintiff such sums as you believe are reasonable and just in this case. Damages are given as compensation for an injury done, and generally, the injury is the measure when the damages are of a character to be estimated in money. If the injury is small or mitigating circumstances are strong, only nominal damages are given. What would be a proper amount of nominal damages is a question for you to decide under all of the facts and circumstances of the case. When a person is injured by the negligence of another, she must mitigate her damages as far as is practicable by the use of ordinary care and diligence. If you believe that a party has suffered damages as alleged under the law, that party is bound to reduce those damages as far as is practicable by the use of ordinary care. If you believe but by the use of such care that party could have reduced the damages, you would determine to what extent and reduce such damages to that extent. To award damages for mental anguish in this case, you must find that the defendant engaged in conduct that was intentional or reckless, that the defendant's conduct was extreme and outrageous, that a causal connection existed between the defendant's wrongful conduct and the plaintiff's emotional distress, and that the emotional harm was severe. The measure is the enlightened conscience of fair and impartial jurors. Questions of whether, how much, and how long the plaintiff has suffered or will suffer are for you to decide. If you find that the plaintiff's pain and suffering will continue into the future, you should award damages for such future pain and suffering as you believe the plaintiff will endure. In making such an award, your standard would be your enlightened conscience as impartial jurors, and you would be entitled to take into consideration the fact that the plaintiff is receiving a present cash award for damages not yet suffered. No plaintiff may recover for injuries or disabilities that are not connected with the act or omissions of the defendant in this case. There can be no recovery for a particular plaintiff for any injury or disability that was not proximately caused by the incident in question. In a tort action in which the entire injury pertains to the peace, happiness, or feelings of the plaintiff, no measure of damages may be prescribed, except the enlightened conscience of impartial jurors. In determining the amount of damages, you should consider all the facts and circumstances of the case, as disclosed by the evidence, and fix a sum as you think would be reasonable, fair, and just. One category of damages that you may also consider is damages to plaintiff's credit standing. To award damages in this category, you must find that the plaintiff has proven by preponderance of the evidence that the foreclosure of the property was the proximate cause of damage to plaintiff's credit in some specific way. If you find that plaintiff has established that PNC is liable for promissory estoppel, you may award damages sufficient to avoid injustice that would result from not enforcing PNC's promise. In considering the amount of such damages, if any, you should consider the extent to which plaintiff, in reliance on PNC's promise, changed her position to her detriment by surrendering, foregoing, or rendering a valuable right. You may not award damages for mental anguish under this count of promissory estoppel. If you believe that the plaintiff sustained damages, you must determine the amount of those damages and do not make any reduction in the amount of damages because of the negligence, if any, of the plaintiff. You must also decide the percentage of fault, if any, of all parties whose negligence contributed to the alleged injury or damages. For any person or entity you find did not contribute to the alleged injury or damages, enter 0%. The total of the fault assessed must equal 100%. The court will enter a judgment based on your verdict, and if you find that the plaintiff was negligent in any degree, the court will reduce the total amount of the damages awarded by the percentage of negligence which you attribute to the plaintiff. If you find that the negligence of the plaintiff is equal to or greater than the negligence of the defendants, then the plaintiff is not entitled to recover damages. In tort actions, there may be aggravating circumstances that may warrant the awarding or imposing of additional damages called punitive damages. Before you may award punitive damages, the plaintiff must prove that the defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care that would raise the presumption of conscious indifference to consequences. The plaintiff must prove that the defendant is liable for punitive damages by a higher standard than that for proof of other damages, that is, by clear and convincing evidence. As to the issue of punitive damages, the plaintiff must prove that the defendant is entitled to relief by clear and convincing evidence. This is a different and higher burden of proof than a mere preponderance of the evidence. Clear and convincing evidence is defined as evidence that will cause the jury to firmly believe each essential element of the claim a degree of probability. Proof by clear and convincing evidence requires a level of proof greater than a preponderance of the evidence. In this case, the plaintiff seeks additional sums as attorney's fees and costs. Attorney's fees are allowed only if the plaintiff shows by the preponderance of the evidence that the defendant acted in bad faith, was stubbornly litigious, or caused the plaintiff unnecessary trouble and expense. Attorney's fees based on bad faith are for conduct that shows a dishonest purpose and imply conscious wrongdoing through some motive of interest or ill will on the part of the defendant. Mere negligence in the performance of a contract does not establish bad faith. Bad faith must have arisen out of how the defendant acted in dealing with the plaintiff and pertains to the transaction out of which the cause of action arose, not to the defendant's conduct after the cause of action arose. I want to emphasize that anything I did or said during the trial of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine, and whatever your verdict, it must be agreed upon by all of you. The court's interest in this matter is that the course be fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as I've instructed you to, and return a verdict that speaks the truth, as you find the truth of this case to be. Your verdict should be a true verdict, based upon your opinion of the evidence according to the law given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. Your verdict must be unanimous. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Jurors should carefully consider all the evidence in the case and deliberate with a view toward reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest opinions or convictions in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. In just a moment, we'll excuse you to the jury room, but do not begin your deliberations until I send you the pleadings, exhibits, and until I send you the exhibits and the verdict form, which I'll do shortly. And then and only then may you begin your deliberations. Beginning with the plaintiff, any objections to the charge as given, other than those already noted for the record? On behalf of PNC.
No further objections, Your Honor.
No further objections, Your Honor. Thank you.
All right, members of the jury, as I mentioned, at this point, we'll ask you to retire to the jury room. We're still going to need to compile the exhibits and the verdict form for you. That's going to take a minute or two, but we should already have lunch for you if you want to get started with that. And then we'll await direction from you. Thank you. Do we have the exhibits compiled? As I requested?
Sure.
All right, I'll allow you to confer and you can just let me know if there's any concerns. Otherwise, the assumption will be when they're just talking about any of that. The assumption will be everything admitted is going back unless you delineate or say otherwise.
Oh, 49.
Fifty-two, 53, 54.
No, that's 54.
Okay.
So you check this out.
Is that 39, I guess?
39. Yes.
59.
No, not 59.
Hold on.
Which are the ones that are coming in?
Hold on. Let's say 59. Does he have 60?
No.
459 and 60 we do not have.
Yeah, so far.
Okay, 72.
Yes.
Do you want to just repair and see if anything?
74.
Yes.
75.
75, yeah.
77.
Yeah.
78.
Nope.
Okay. 79.
Nope.
80.
Yes.
81.
Nope.
82.
Nope.
84.
Nope.
81 was a no, right?
All right, just first observations on the punitive damages. I'm just talking.
88.
Why don't we just combine 11 and 12? I'm looking at the defense version. Just put the standard of proof inside liability. You see what I mean?
No.
Find that they were liable by clear and convincing evidence.
109.
No.
Like, I'm not going to put 12 into 1. Yeah. Or sorry, 12 into 11.
Is that part of one? It's hard to tell.
130.
Yes.
142.
Yes.
You can go ahead and give them the lunch. Good.
23.
223. Yeah, we have 220. Yeah.
So like, let's on question 11. Do you find Wells Fargo's actions showed, comma, by clear and convincing evidence, comma, willful, whatever. I'm writing it here, so I'll just get it.
These are good.
And I'll do that same thing with PNC.
So I don't care about that.
It's in.
So these are,
These are good.
These are good.
These are good. And I'll start
It's just a letter, right?
piling these up.
If you give me the
so-
good ones, I'm gonna stick them in the binder.
By, yeah. Okay.
Well, I don't,
You open this case.
so I do have 81 here, but I don't think this whole thing is showing the.
Did you check out 81?
yeah,
Definitely in.
you need to check
What do you
anyone.
mean?
So the question is about
What's
if
the
it's
question?
the entirety of.
I don't like the emphasis on the horrors.
But there's a lot attached, which I don't think.
They were all in there.
As
And there,
one giant exhibit.
remember, it was a letter to you July 20th and it had all those attachments.
Yeah.
Well, that's fine.
Can't believe I haven't wiped out some of these documents.
All right, where's promissory estoppel?
Okay, so these are bad and those are good.
Yeah.
Any issues with ours?
No.
Okay, so these, we had, I thought are almost all exhibits in ours anyway, but these we don't have
Okay. we can
admitted
double-
by plaintiff.
Yeah.
What's?
These are the big ones? Yeah, of course. Sorry, can I take a moment to go?
Actually, Mr. Tobin, do you, do we need to put on the record what's staying, or how much time? Because we still want to get them the verdict form so they can get started. Do you have time, we think, to knock that out, or do you need to step out?
Yeah, my thought on the verdict form was that maybe you should take a look at what we gave you and see what you want to do.
I'm looking at it. I'm ready to talk about it.
Okay, that's great.
Okay, we can go back on the record. All right, let's go back on the record. Is there anything we need to note about which exhibits are going back or not? I'll just leave that open to the parties.
We're still reviewing, Your Honor.
I think you're on I think defendant's submission to the jury is acceptable to plaintiffs, is what I was advised, but there's some questions about plaintiff's exhibits that are still being reviewed.
Okay. All right, so I've now got proposed verdict forms revised from both counsel. And I'm looking at those now. I'm going to print off a copy to show you what we come up with. But one thing I'm already planning to do with the punitive damages section, instead of having that be two questions, I think that can be combined, where it would just be, do you find that the plaintiff showed, comma, by clear and convincing evidence, and then the standard. I don't think that needs to be two questions, so I've combined the punitive damages section. On plaintiff's request for the special finding, I see the point of your argument, which is that defendants should not, as a matter of law, been able to argue that that notice precluded altogether the attorney's representation or the agency there. I don't think that argument was one that they actually made in their
They did make that,
closing.
Your Honor.
Sorry?
They did make that argument.
Well, I think there's more nuance to it,
Specifically,
but this is
argue
the
that-
point where you can preserve your issue. So why don't you go ahead and lay it out?
thanks, Your Honor. It's specifically what they argued that, had she checked the other form, then I would have gotten a notice, but she didn't do that. And I think that's also against the law. And I see no harm because it's a simple line and it will provide clarification should it be necessary. So it's not overly confusing or doesn't do anything else.
And the argument was explicitly that that was not enough.
Exactly,
That
Your
would have been
Honor.
a first step. So in our view, Your Honor, just adding the special interrogatory would not be helpful or be appropriate. It's sort of focusing on one particular element. We've got all the other elements. Wrongful foreclosure is a 4-element tort. So just picking one out and asking the jury to ask a special interrogatory on that one. We're not going to be able to figure out what the jury was thinking or on what element the decision rose or fell. So if that special interrogatory is answered, that will imply that it somehow was the determining factor and it won't necessarily have been that. So it doesn't really help with the appeal. It just sort of creates some ambiguity and frankly, it might just create an issue. We think it should not be included.
Just for the record, let me state, since this wasn't filed in any way, the request is the special interrogatory should read as follows. Do you believe that the quote request to release loan information to a third party quote form means that PNC was not required to send notice of the foreclosure to Fei Zong's attorney, Yasha Haydari? Mr. Howard, you also seem like you want to add something?
Objection. I think it's prejudicial. I think it's unduly suggestive. I think Mr. Hidari had an opportunity to present this entire case. He wants to highlight one issue for the jury. And Your Honor, if that's permitted, there are several issues I would like to highlight with special interrogatories that would just point something to the jury that I didn't feel like I successfully pointed to them in the course of the trial.
Okay, last word, Mr. Haydari.
Your Honor, like I mentioned yesterday, I believe that this issue has been decided as a matter of law. And I don't think that question is that difficult. I think it will shed a lot of insight, should it be necessary for further review. I think there will be further review no matter what happens. And I think Your Honor has the discretion, especially upon the request. And the case law says that situations like these, the request should be made and it's within the trial court's discretion, but it's a proper request for a very limited question.
All right, understood and noted. And again, after several reviews of, over and over again of this appellate opinion, the issue that's highlighted here and the phrasing of the special interrogatory, I don't see the utility of it adding enough to this case. I think it just risks bringing a lot more injecting a lot more into it than it's worth. I don't know if this, I don't think, as argued by in closing, that I heard what the Court of Appeals was addressing here, that line was crossed. And I also have concerns that it highlights a specific aspect of this case that that otherwise wouldn't be highlighted in a verdict form. So I'll deny defendant's request for that specific special interrogatory. The objections noted for the record. As to the remainder of the verdict form, I'll print off what I have now. I think from defendants, what they sent over, I think that was very similar to the plaintiff's most recent. The only, again, thoughts just keep occurring. The only thing I wonder here is now that we've got a separate spot for damages for the one claim and damages for the second claim, would we want to put anything in this verdict form or just wait to see if there's a jury question about, hey, we think the plaintiff only proved one of the two claims, or sorry, strike that. It would be more if they proved both of them. And so do we put the damages for both, meaning they will be added together, or do we do it collectively? Do you see what I'm getting at and how we should address that?
The defendant's position is based on what's been argued, that there's only a single injury. So if there's 3 million on two different claims, that's not 6 million, that's 3.
And that's what I want to wonder, whether we need to make that explicit in this verdict form, or we got this on the front end.
We could fix that afterwards if the court.
Your Honor, that is not our position at all in terms of one single injury. We requested 3 million for promissory estoppel. We requested 3 million for wrongful foreclosure by Wells Fargo, and we requested 3 million for wrongful foreclosure for PNC.
Only one injury was argued. So how could there be 3 different injuries?
I think that the easiest way, again, in terms of determining the juror's intent, would then be to add a final question, which is what would be on a basic jury form, which is what is the total amount of money you think is owed to the plaintiff? All right, so I would add that right before, excuse me, that'd be right before the punitive damages section. So that would be a question.
Your Honor, I'm sorry. I have some concerns about that result because I think that it's going to look like they just add it together like a simple math problem, and that's not at all what we're saying. I think it should be made clear that it's one recovery.
I didn't hear that comment by Mr. Howard.
And why wouldn't they, if they're saying that, hey, I find for you on the one claim, you get this much because that's the damages there, and I find for you on this claim, which is totally separate, and here are the damages here. And so the total amount should be adding them
I
together.
think, as we said before, Your Honor, this has been presented as one injury. And I think it's just going to be confusing. I think it's duplicative. I think it's going to be prejudicial because it's going to risk that the jurors don't understand that distinction.
I'm happy to try to figure out that distinction, because you're certainly right, it's confusing. So why, as a matter of law, do you think they're not entitled to seek and obtain separate recoveries on both claims?
They'd have to prove separate injuries. And if they could prove separate injuries for 2 separate claims, they would be entitled to 2 recoveries. But we haven't heard that. We heard the identical number for each one, and we heard this exact argument applied to each of them. So that means that there's only one injury that could be recovered here. Maybe the jury's gonna say they get it for one and not the other, that'll make it easy. If they say they get it for both, then it's just the one. And if it comes back the exact same number, that's gonna be pretty indicative that they view this as just a single recovery they're occurring on the.
Could be. I don't know. I could see that being interpreted both
The
ways.
court certainly has a role here too.
Yeah.
The court can look at the jury form and reform it so that if it is just a single injury that's been proven, then the judgment that would be entered would be for that single injury, not a duplicative recovery. Duplicative recovery is not.
And do you think there'd be any issue with if that is, when we get this verdict form back, to then sending them an additional interrogatory or question to tease this out? Should it be an issue?
That would be, I think it would be appropriate.
Okay.
Your Honor, I respectfully object. And if we were just focusing on one single number, I could have easily said award 9 million. Instead, I specifically highlighted what I wanted the jury to do based on our discussions of how we broke this verdict form out. And I believe Your Honor's suggestion of having them added together so they can give a total amount that they believe the plaintiff is entitled to is an excellent suggestion. It sheds light into exactly what their intent is and makes sure there's no question that they're doing what they intend to do.
All right. Well, there's nothing in the instructions really on the issue. Let's see if we can figure out where they are first. If this is actually an open question of law about one injury versus one recovery, and I'll flag the issue. Maybe we'll have to go back and get greater clarity from them. And so, as for now, let me see if I can print a copy of this, and we can take a look at what we have. Let me save it. In the meantime, can y'all keep looking at exhibits?
Yes.
Are there any more exhibits that you found that weren't good? Where are the plaintiff's exhibits, by the way? Oh, there.
Here's the two that we know were admitted that you said were previous, yeah.
60 and 78. Can we check the transcript on those?
Yeah, that's,
Actually, I'm not sure about 78. Oh, 60 and 78.
Printer's not working on me anymore. So I emailed
Agree
it
on this,
again.
Yasha, 78 can go in.
Oh, wait, and shoot, delete phase one off the,
About 60?
We don't see 60.
I see 60.
actually, I guess it doesn't matter because it's not like we're hiding something from them. Yeah. Just leave it on. That's fine.
It's the April 4th letter, yeah.
the video.
Let's just do 3. Yeah. And then email it.
Huh.
Just if you email it, we only need 3 copies.
Yeah, the owner can confirm.
Oh, yeah.
Actually, were you talking about that 40,000 number, was it phase first testimony or is the morning after that number? I think it's the first months after. It's the morning.
So just check to make sure that that's all still consistent.
Yep.
Oh, we just said 78, right? Yep. On my list, write it down. Okay. 59,
So I think we're down to one document issue.
61.
And that's plaintiff's exhibit 60. It's okay.
It's part of that.
The court, there's, we're still trying to see if we got it. 60.
60?
60.
Okay.
Two.
I had a fax, though.
Well, they weren't great, but I'll see what I got.
See mortgage. What is that?
Uh, boy. Yeah, you want to take it, get out of here? That's fine. Yeah, you know, what? I don't even think we're gonna need, we can put it on the record later. You're fine.
What's that?
They might need you to search your Control F though,
Seven.
or 60.
For today?
No, it'd have been, here we go. I see it. Yeah, I see it was referred to, but not admitted. This would have been, I'm trying to see who it was through.
82.
This was day 3.
7, 3, 4.
I can advise everybody that the letter is Johnny Exhibit 58.
I have a P60, is that what you're looking for?
Yeah.
Yes.
Thank you.
Yeah, I see Mr. Bevins.
I'm going to another letter that gets a little more explicit. Let's go to P16, that was by, Mr. Haddad.
I'm not showing it was ever moved to be admitted.
Hold on, let me find if it was not.
Oh, you didn't think. Oh, I see.
Yeah, it was not.
It's not- this is-
Okay.
I got you.
All right. Any other discrepancies, or we think we're clear now?
No. Not on that day, you want me to check if it was submitted on the next day?
Do you mind checking, please?
92.
I don't see any other 60 on the next day.
That's fine.
What do we got? You can just give one each.
Your Honor, is there any harm to having them added up?
Having them added up.
Yes.
There may not be. Let's see what they come back with first, and then maybe we'll go from there. Maybe they make it easy for us and say all on one, all not on the other, or whatever.
You care about this being there?
Oh, Your Honor, could we please remove the language for phase 1?
Yeah, I was wondering about that. Is it really is there really anything we're trying to hide from them? Because there's a phase 2. I understand we usually would bifurcate it in a criminal case because we don't want to tell them that someone's a convicted felon. But if they find that there's going to be punitive damages, is it really a problem that they know there might be a phase 2 where they have to determine the amount? I guess that was kind of the point.
I see it being unduly prejudicial to the person seeking punitive damages, knowing that if they award punitive damages, they will have to
Sit back in
sit
court.
back in court.
Come back.
And that may
Okay.
be the purpose of the statute.
Okay, we can change that title. We would cross off for phase 1 while we're printing off another copy on question 11, I don't think we need the, if your answer is no, proceed to question 2. It would just, that's the next question.
Your Honor, for number 12, there shouldn't be a question for Wells Fargo because I thought we already established that we're entitled to attorney fees because that's been admitted.
That's right. So 12 should just be omitted entirely.
Sorry, what did you say, Your Honor, about 11?
11, we don't need that final sentence, especially since there will be no 12. All right, anything else?
Here, Your Honor.
Catch all that?
Yeah, number 7. If your answer is no, proceed to question 9.
So it's this. So on question 7, instead of proceeding to 8, it's proceeding to 9.
Your Honor, on 10, I don't know if this was raised before. I don't know why the first sentence is at all relevant. And it seems to lead the jury to find punitive damages because by the like.
Going off y'all's working copies.
I'm sorry, Your Honor.
All right, so I'm striking the first sentence from 10
From 10.
and as such as well.
And as such.
I don't have any further.
I don't hear Your Honor. That's fine.
Yeah, so that's instead we. Just strike that one. So the last sentence of 9, also where we have them kind of bouncing around.
Just this. It's just.
Okay,
Your Honor, just as a matter of pragmatically how things would move forward, let's just, and I know it's an assumption, but let's say that the jury did come back and were what we requested for each of those 3 sections. At that point in time, are we going to send them back and have them clarify? That seems like a inefficient thing to do as opposed to have them just add the lines now or say this is the total room we intend to award.
I want to get them started, is the thing. And so we can still keep discussing that language while they're deliberating. But I want them to get started, and I think they're eager to. So I'm still open to the distinguishing that and the hearing argument on it, but we can get this verdict form and this to consult on.
Whereas are we didn't find we needed to.
Yes. Okay, I'll try to.
Do we have PhD opinion? One to 2, I'm just
It wasn't in this one.
Yeah, I don't think it's.
Good.
All right, we got them stacked somewhere.
Yes.
All right, just make a note of what's going on, what's going out. We'll make a record of it when she's back. If you could also take Courts Exhibit 1, not 1, I think it'd be 2. 2 might be right underneath that. That's going to be the charge. Yeah, that one. And then I'm going to mark as Courts Exhibit 3 the verdict form whenever we print off the next copy of that. And we can give those to Deputy Scott, what you're holding right now. Just two, because that's the consolidated.
Binders as exhibits as well.
And then, yeah, whatever you've agreed to go back as exhibits, we'll hand those to Deputy Scott.
I think we're ready.
And then, well, we just need to wait until we get a verdict form on top of that.
So do we want to go through the list right now?
Well, we got no court reporter. So just make a note of what you think is staying in, staying out. We'll make a record of it while they're deliberating,
Write it down, Mike.
assuming there's no objections or anything we need to work out before sending it back.
Jury, are we going to make the record before it goes back?
Unless there's an objection that you need me to sort out before, and I'm saying we could make that record when we get our court reporter
Oh,
back.
okay.
Is there an objection?
I have no issues with that.
Yeah, you should just write down that we did right.
Okay, we're just gonna note what's going back for the record.
But there's no record here. She's not here.
Well, just so we know exactly what's going
Oh,
on.
okay. All right, I'll listen.
You're-
And I've got a copy of that. So this is good. Defendants.
And you're gonna have to do this all over again when she's back, right?
Yeah.
Okay, all right.
And I think we're ready to go.
Yeah. Student council. Here's number courts exhibit 3.
You got him, Your Honor.
Well, we can wait a minute now that she's made it back. All right. We're back on the record. Any announcements regarding which exhibits go in and which stay out? Let's begin.
For plaintiff, we have. And these are all P exhibits, 49, 50, 51, 52. Oh, I'm sorry. Strike that. I'm starting from scratch. So for plaintiff's exhibits, we have P 39, 78, 49, 50, 51, 52, 53, 72, 74, 75, 77, 80, 87, 134, 223, 142.
All right. Any objections to those exhibits going back?
Difficult. That was quick and out of order, Your Honor. I heard 79 and I didn't think 79 was one that we had found or discussed.
I don't think I said 79.
Okay. I'm sorry.
Why don't you just show him your list?
Sure.
Should I make the record of the defendants list while we're confirming whether we have objections or not? Defendants are sending back joint exhibits 1, 8, 9, 11, 12, 13, 16, 17, 21, 23, 25, 27, 28, 30, 31, 32, 33, 34, 35, 36, 38, 40, 42, 43, 44, 46, 47, 48, 49, 50, 51, 54, 56, 59, 61, 62. Too fast.
54, 56, 59.
61, 62, 63, 64, 65, 68, 71, 74, 75, 77, 79, 81, 83, 84, 87, 89, 90, 97A, 97B, 97C, 97D, 97E, 97F, 97G, 98, 101, 103, 104, 105, 107, 111, and P and C Exhibit 4, and Plaintiff Exhibit 314.
Any objections to those defense exhibits going back, Mr. Hadary?
No, Your Honor.
Yeah, and for the defendants, any objections to the plaintiff's list that was read previously?
No objections, Your Honor.
All right, I've now, I believe, handed you an updated special verdict form, which I would mark as Court's Exhibit 3 and add to that stack. Any final thoughts or opinions about this special verdict form?
Yes, Your Honor. I'm going to once again come back and request that in light of defendant's apparent argument that these are single rights of recovery, which we dispute, we specifically requested 3 separate figures for 3 separate areas, that we simply have a line, which Your Honor was the one who initially suggested, is that have the jurors add them up saying this is what the plaintiff is entitled to. And that would clarify any question, any doubt whatsoever. Yet defendants oppose this. So to the extent there's any ambiguity or any question otherwise, this is an error that the defendants are creating themselves. I've never had a situation where the jurors come out, read their verdict, and then they go back and clarify their verdict. It's just, I just haven't experienced that. I don't know if that's a possibility. That seems very odd. But considering it's just a very simple request, I think it would make sense to add it. And I think defendants' refusal to add it would be their, any confusion would be through their creation.
All right, and any argument you want to have on the record on that point, Mr. Tobin, about why we should not have a special finding there of what is the total amount of recovery?
I think I'm satisfied with the record of argument.
I don't know if we made one, though.
When we were discussing it, it was on the record. Okay, thank you. Our position, Your Honor, is that plaintiff only argued a single recovery. So really the problem is the plaintiff is now indicating that it wants duplicate recovery. So I think the court has afforded plaintiff an opportunity to fix its own problem by suggesting that if the jury does fill out the verdict form in the way that we're discussing, court will provide the jury an opportunity to clarify, which is very beneficial to plaintiff. We don't object to proceeding in that fashion, but we would object for all the reasons articulated by Mr. Howard before, which will probably repeat, to including that on the verdict form that goes back now.
Okay,
Your Honor, if I may,
well, let's let the defendants.
The way it's proposed will be prejudicial, and I think that Mr. Hadari said that he wants the jury to add them up, which I think is a good demonstration of why we're concerned about the duplicative nature.
Your Honor, if I had wanted to, I could have suggested a single amount of 9 million. I did not. I specifically went through the 3 causes of action and what we're requesting for each of those 3 causes of action, Your Honor. And so.
All right, well, look, I mean, I'm going to take a look. This is an only issue created because we wanted to subdivide. And I didn't see as in your argument that you were limiting yourself to a total figure. I mean, you broke it down. I don't see as a matter of law on the charges that say it can't be an injury allotted to each thing. Let's see where we get. So I'll consider it once I see how the verdict form gets returned. I think that may need be something we do need to spell out considering on the circumstances. So noted. For now, though, I think any other objections to Court's Exhibit 3?
No, Your Honor.
That is it, Your Honor. Thank you.
Okay, so we've got the exhibits, we've got the charge, we've got the verdict form. We'll send those back. We'll note the approximate start time of deliberations is 12:45. I would say, I think we've got an email for everyone. So if we get any indication, we'll send out a mass email. And in about an hour or so, maybe we can come back, or we'll see if there's anything else we can start talking about, just to make the best use of our time. If there's going to be a phase 2, if we're going to send back more special questions, what those are going to look like, just so we're not waiting until we get the jury's verdict to discuss those things. So with that, why don't we just go ahead and plan on coming back at around 2 o'clock if we don't have a verdict before then. All right, if there's nothing else, we'll be in recess until 2 o'clock.
I'll show you over.
Dylan, I meant to ask you earlier, do y'all do any work with Cadwalader at all? Cadwalader. They make a lot of work past security.
No.
They made the 2004 following. That's why.
Oh, okay.
I called my friend there, I was asking how it all worked.
Yeah, yeah, so that's esoteric stuff.
Yeah, no, it's, it's hard. Yeah.
I was gonna say, I'm deeply honored when you called me Dylan.
Oh, yeah, well, my wife's name is actually Dylan.
Really?
And her dad is an English professor at Alabama.
Oh, okay.
She was named after.
There you go. And my parents were hippies, named after Bob Dylan.
Yeah.
Yes. He gets popular again. I hear that all the time.
The comedian Brian Regan has a bit where he's talking about, he's watching TV and he hears something about, Brian Regan's attempted to assassinate the president. Different Brian Regan, different, unrelated. But every time I was listening to music, I would get an hour. I was like, I was like, can't be the same guy. No, can't be the same guy.
I swear.
Yes. Do you make them?
No, thank you. Kim, there's a bag here, could be Dylan's, just don't know.
Oh, it's Dan's actually.
Dan's,
Oh, wait.
maybe. Yeah, it'll be sweet back though. Yeah, that's what I see. We will see that before you come back.
Oh.
Somebody's back.
Just anyone? That one isn't really moved. Oh, see, it's right. Gotta take this one. It's not. Did you hear the closings? I have a part of it. You stop.
Now you.
we have an extra chicken sandwich.
I'm good.
You're good?
Yeah.
Okay.
Thank you.
No problem. Madam Court Reporter, we have an extra chicken sandwich.
Thank you, I would.
Oh, you got, okay,
I
you got
appreciate
something.
it, thank you so
Okay,
much.
no problem,
Continue.
no problem. I just happened to have one more. I offered.
Sure, you don't want to actually say, oh, I just, well, we had. Get all the. I appreciate it.
He ate the jurors pizza.
Yeah.
Trying to decide, I go this way or take the long way around. It's the same, actually.
you watch the closing arguments? Not really, no. I always like to ask deputies, court reporters, what they think. It's always, getting always my, I guess, my 13th, 14th jurors and like, what do you get? Is there even evidence? We'll see what happens. Nobody wants to get outlined. Exactly. I appreciate you being here. Hello.
You know, I'm exhausted if I'm drinking a Mountain Dew. I've drank one of these since I was a kid.
That's do it for me with you.
Does it good, cause I'm going on 2 hours of sleep for the last 3 nights.
Here it says the affidavit of the Wall Street in support of. It should say to be back at 2, do you remember?
2 o'clock.
Yes, there's a big garbage can outside the hallway as well.
Okay,
It's the trash folks, well, housekeeping don't go in that room at all. I get
Okay.
rid of the trash.
got it. Okay. Make sure to move the trash. Oh.
I see, yes.
Should be back. Yeah.
Is that everything or?
Yes. No. Anything you, me.
How do we know when the jurors are ready?
Oh, they'll tell us.
Oh, he's talking about lights. Are those the lights he's talking about?
It's that light.
Oh.
There's so much of that was getting like and he was coming. I could have stopped it. And then I pushed it by going further. Should have just dropped that. But
It was like. That you should know. That one was.
that was all.
Oh, my God.
I did it right.
Yeah.
Yeah. I was.
Yeah.
It's crazy. Or excuse me, the trip. You know, yesterday. I bet that's. Right. All that. Yeah. Yeah, keeps you awake. Yeah.
Exactly. I just hope everyone appreciates it. You guys have been cushioning.
Oh, I should have brought.
Stay in cushion.
Well, I'm glad you have it.
I thought I would have liked it. I feel bad now. I should have brought it for you. I thought.
It's the one from the hotel.
I know what you're.
You won't pay for everything else.
I had one of these.
I'll just. And this Tuesday, yeah. That's the baby.
We can always like, our Instagram or anything. Or convenience. What really, what more?
I was, I promise you I was. I was going to.
First day. Just for.
It's yours. Yeah. My wife's learning from college. But the house you first time days ago. in Google Maps.
You should check it out in full.
Yeah. That sounds like something I need to do right now. It's not.
Are you looking for? Are you looking for?
Yeah, she go too, I'm just the tree.
Yeah. Yeah. I think maybe thanks. Thanks. Yeah. See you Monday. Get off.
I don't know if this needs to be on the record. I'll check with the council first. See if we can give you a break.
5 days.
Yeah, that's all. Oh, okay. We got everyone here. So I mentioned I don't know if we need to go on the record just yet. I mean, I really just want to kind of see what the parties' positions are and kind of game out some hypotheticals just so that if we can anticipate or in the eventuality, whatever the jury decides to do, we can hit the ground running. So if at any point you think this needs to be on the record or whatever, we need to memorialize, just let me know. But otherwise, just kind of dive into it. So just kind of want to walk through the possibilities here and how that might, what we might need to do for phase two. So possibility number one if there's any amount of compensatory damage recovery against Wells Fargo, then then let's explore what that's going to look like. And so, Mr. Haydari, I think you had initially said your anticipation was to call yourself as a witness. I'd imagine maybe your co-counsel will be examining you.
That's correct, Your Honor.
Okay. And I think you'd mentioned you need, what did you say, 20 minutes for that?
Yes, Your Honor. I don't think it'll take that long, to be quite honest, but I want to box myself in, but I don't think it's going to be a long, direct examination.
And the intention was not only to cover, generally the time you put into it and the reasonableness of a contingency fee, but was also to introduce some costs and that sort of thing that you've already accrued.
Yes, Your Honor. I don't think my ledger even brought up the cost, which is fine, so I'm not going to really discuss that for.
So it would solely be, I've got a contingency fee and it's reasonable, essentially, to have a contingency fee.
Yes, but I will discuss the costs in terms of how much the costs are approximately within the course of this litigation. In that Devereaux case we cited, we're supposed to talk about just how much time we put in, how much cost we spent. This is a copy of my agreement. This is a ledger. And again,
The purpose of that being just to show that they're reasonable.
correct, in terms of a contingency arrangement, but let's say hypothetically that the jurors come back and say, well, it's $1 in nominal damages in terms of that's all they are awarding for anything. I could still come back and say, well, even with the award of $1 nominal damages, this is my request for attorney fees. I wouldn't stick to the 40% at that juncture. I'd say, this is how much time, this is a reasonable time and expense.
Well, that's why we're here now to kind of game out these alternatives. So let's start with compensatory. If it's anything more than $1, or if it's anything on compensatory.
Even if it's, as long as it's less than my actual 40%, then I would be discussing my reasonable hourly rate, and I would be discussing how much time I put into the case, and that would be my request.
Okay, so maybe from a top end, what you're saying is you're reserving the right to basically go under either theory, either contingency or time and expenses.
Yes, Your Honor, and I think one thing that I mentioned
Okay.
initially, very just can't come in the word of bonus. So just hypothetically, if I come back and say, hey, let's just say the jury awards $1 billion, I can't come back and say, well, give me the 40% plus. I want my higher hourly rate and everything else, because that exceeds my contingency fee arrangement and it no longer falls within the scope of reasonableness. But if they come back and award $1 in compensatory, $1 nominal damages, I can say, well, look, this is how much money my client spent. This is how much time and money I spent. And so based on that, we'd still be entitled to.
Yeah. Well, I think that's what I wanted to kind of clarify. So let's hear it.
Start your own and say if the jury awards $1 and Mr. Hadari is awarded 40 cents and he demands $500,000, that's a bonus. It's a bonus just as if they awarded.
So where's the law saying someone's locked in to a particular theory?
Your Honor, I haven't seen any case law that allows somebody to jump around. I've seen cases.
We can keep talking. That means they either have a question or they got a verdict. No.
I've seen case law where if you're approaching it with a contingency fee theory, the jury on their own may have some authority to go a little higher if they think that's not sufficient. I've not seen any authority. I've not seen a single case where somebody can come in and say, here's my contingency fee agreement.
All right.
I only want the upside of that. I don't want the downside.
I mean, there's nothing in the instructions, the pattern charges. I couldn't find anything in the case law either. And so, and if there's no prohibition against it and the jury's just allowed to say, hey, you get to consider what the damages are, and he presents his evidence of what the fees are, whether it's contingent or whether it's the hours worked, what stops him from just putting out all that evidence and saying, you, the jury, decide?
Unfair, Your Honor. I mean,
Wow.
he reached an agreement that said he would take 40% of whatever the recovery is. And there's obviously a big upside to that. I think it's $9 million. He walks out of here a lot richer.
Yeah.
But if he gets $1 and it's 40 cents, you have to live with that side of the deal too.
Um, they've asked for highlighters. They want to be able to write on the exhibits. So, unless you want me to, I can write this on a note if you want me to, but I would tell the deputy to tell them they can have highlighters. They should not write on the exhibits, and we give them blank pieces of paper if they want that. Unless there's any concerns. Okay. All right. Other than just general, notions of fair play and justice. Yeah. Okay. So bottom line, even if there's just $1 on nominal damages or $1 on compensatory. Well, how about, let me ask you this. If there's 0 on both, Mr. Hadary, would that be a case where you believe that the underlying claim has failed and then no attorney's fees can flow from that?
I have not considered that possibility. Ordinarily, 0 is absolutely the end of a request for attorney fees. The implication of Wells Fargo's default, the language is that in terms of what the defendants can prove, they can prove that damages, they can contest the amount of damages, not that the plaintiff has been damaged, and they can contest it so far that they basically approach 0, so that they are 0.
But if a claim is the 4 elements and one of those elements is damages, and they've come back and said 0 damages, has not then the claim itself failed?
That goes back to that Flynn case from a long time ago. And there's been a lot of cases in its progeny. I think more likely than not, this seems like it would probably be one of those appellate issues because I see an inherent contradiction in what should be the implication of default, as well as a lot of case law that discusses the fact that if you can't recover on attorney fees are supposed to be ancillary. 13.611 is contingent upon recovery of the underlying claims. And so I think those two positions are somewhat at odds. And I think there is some tension in the case law there. For that reason, more likely than not, I'd have to consider it, but it seems like an issue I'd want to preserve for appeal. And I would probably still request the opportunity to go forward. Unless the other side simply stipulates to the fact that, whatever number is my reasonable attorney fees, and at that point in time, Your Honor, I think that's a little far for me. I need to think about that.
Okay, but it's one of those, that's why we're doing it now. So we can just think through those hypos. So 0 is on the table. I imagine defendant's position would be, hey, that means everything stops there. The underlying claim has failed. All right.
All as well. Will the jury charges read if the jurors find that Ms. Zong has 51% of the fault, then they may not award damages and who's part of the damages. So that would also obviate the need for a case too.
Okay. All right. So that's 0. And then, but back to the 1-1, other than a general objection, right now, I believe it sounds like plaintiff would just be putting it all out there. And then based on the pattern instructions and the instructions that we have, it's just kind of left at that. Now, in argument, you can raise all these things that you've talked about, but as a matter of law of how they're supposed to calculate the amount of attorney's fees, I'm not seeing anything that locks someone into a contingency, or if they change midstream, they can't go back in time. And so I guess we would just go from there and see what number they put down. All right.
Are we on the record, Your Honor, or are we off the record?
We haven't been, but we can at any point. I'm just, again, I don't know if these are pages that we really need.
The thing that I want to raise probably on the record in a moment is the issue of dealing with the attorney fees and the punitives in the same phase. I probably request that we just address them, or you trifurcate it. You hear my attorney fees because they requested it, and then they go back and deliberate, then they come back and we address punitives.
Why that?
It was my current concern from the original statute where they're supposed to be kept separate. And that's one of the reasons why I really wanted to address the attorney fees in the first phase, because I think the jury should have been able to hear them in this compensatory in nature. And, that was my argument. I'm just trying to prevent reversible error.
Mm-hmm. Wouldn't that, if that's an error, isn't that one only in your favor by having it all in one kind of lumping?
I mean, not if it's reversible.
Well, I mean, I guess the point being is that, okay, I guess it just depends on who would raise it as an error. All right, and then in terms of the actual testimony itself, is there still anything, now that I think we're kind of clear on the positions of the parties, is there still anything that can be stipulated to or agreed to in order to streamline that testimony? I guess one would be the reasonableness aspect of it. I guess they still want to get in the amounts of time and money and that sort of thing, but the legal conclusion in the language of the most recent Devereaux case, I don't know if that's a whole line of questioning that we could obviate or not. But anyway, I just put that to the floor. Let's see if there's any way we could streamline part two.
Your Honor, when you refer to Devereaux, are you referring to the sufficiency section? Is that what?
That's more looking at you, Mr. Howard. Okay. Okay. All right. Then the last point, then there'd be a direct and cross of Mr. Haydari on attorney's fees. In terms of instructions that I give to the jury, is there anything that you would ask that I and think I should charge them on? Deputy Scott? Deputy Scott. Deputy Scott. Yeah. Is there any other additional instructions you think I would give them at the conclusion of part two? I could just give them a copy of this again. It really doesn't, again, talk though about the amount of attorney's fees damages. It just talks about what they are and whether they are. So I don't even know if there's any additional instructions I would need to give them other than you may now retire to assess the amount of damages that you deem appropriate.
I have nothing additional to add to that.
Okay.
Your Honor, is it your intent for us to both address that issue and then also the question of punitives and then they go back and just deal with both at the same time?
Mm-hmm.
I would want to see, Your Honor, sorry, I may be speaking out of turn, but I would certainly, we want to be able to reanalyze that after we see how the testimony goes and see what issues did in fact arise.
Well, I mean, we're certainly going to take a look at the verdict form, and that's going to determine what we're doing. I'm trying to game as much of this out as we can. And in terms of both sides closing again for part two, I would propose I'd be capping both sides to, PNC may have already packed their bag and headed on home. But if it's just, we'll see who's still around, but I would propose a cap of 10 minutes for each party for closings on the issue of punitives and or attorney's fees. Anyone want to be heard on that?
Sorry, I don't understand the suggestion, Your Honor.
I'd be the clocks again, 10 minutes for each party's, not each party's, each side's closings on attorney's fees and punitives.
I'd probably want a little longer than that, Your Honor. Not too much longer, but 20, 25 minutes on.
Okay, I'll take that into consideration.
Thank you, Your Honor.
Anything else?
I said that was fine with me, Your Honor. I was assuming in giving that answer that we were going to be arguing on attorneys, like I would be arguing attorney's fees on that Wells Fargo. That would certainly, I could do that in 10 minutes or less. But I didn't think through, the possible conclusion that we end up arguing much more extensively on
punitives. Yeah. Okay. Another thing to flag when we get our verdict form back and we see, these are just the things I think we need to figure out quite quickly once we get the verdict form. All right. And that's all I can think of. So is there anything we want to put on the record that we just discussed and note? I think you have a trifurcation issue you want to note. Anything else?
Yes. Are we on the record or not yet?
No, we're not yet.
That's the only issue.
Okay. Then if Madam Court Reporter is ready, we'll go back on the record. Time is 2:20. We're still waiting on a jury verdict or question. We've received neither. We've had some informal discussions about what part two of the trial would look like. And plaintiff has an issue he'd like to place on the record to preserve.
Simply that, Your Honor, I am requesting trifurcation so that we can deal with punitives separately from attorney fees, and that the defense wants to deal with, I guess, in the second phase together. So
All
that's,
right.
that's
Any
my,
position on behalf of both of the defendants?
Um,
Should trifurcation be necessary?
Certainly object to trifurcation of the case. I thought that had already been ruled on and a record made. Yes, sorry. Thank you. A long week, Your Honor. We just wanted to make an objection for the record. I object to Mr. Hidari signing a contingency fee contract, proceeding on that basis, accepting the upside, and then somehow reserving the right at trial to argue that, in fact, that was not the arrangement he should be held to, or he should be allowed to argue for hourly attorney's fees. And he's presented, I mean, it was the day before a trial, I recall, they presented an engagement letter or retainer agreement related to contingency. He has never presented any evidence of an engagement related to hourly fees, and he has not presented what I've seen admissible evidence about the value of his fees or the time spent.
that comes from testimony.
Okay, so I see that raising some new issues if there's some kind of a discovery violation being alleged, or when you say admissible evidence, maybe there's a rule of evidence you think is at play here that we need to apply to this. You know, that's some things we need to, I understood our initial discussion as being that as a matter of law, he just can't pursue these alternative theories or be able to pick or choose. But the nature of your objection suggests to me there may be more, but I'll let you complete it.
Sure, I mean, I don't know if objections over the evidence rules are ripe yet, Your Honor, because I don't actually have a good concept of what he's going to be arguing or what testimony he's going to be presenting. I think there are some real evidence rules with the statement of fees that he has provided, assuming that he is going to be trying to collect those versus using those as justification for the attorney's fees. I think those are very different standards he's going to have to meet, but again, that may not be ripe yet because we haven't gotten down that road.
Okay. Anything else?
No, thank you, Your Honor.
All right, then we'll be off the record. I will say if you've got some kind of like thing that maybe it'd be nice for me to know it now so I can think through it and not to be
Sure.
put on the spot.
Well, just quickly, Your Honor, and this won't necessarily be comprehensive. Obviously, I've reserved the right to make objections later. Mr. Hidari provided a statement of his fees that does not appear to qualify as a business record. Now, I don't know if he intended to use this as a business record, so I don't know if it's going to become an issue. And obviously, he would have to lay the foundation. We'd have to address it at that time, but I do anticipate that's going to be something we may be arguing about later.
And is this because it was not attached as an exhibit to the pretrial order?
It was, Your Honor.
Yeah, it's not for that reason, Your Honor. It's because it doesn't have all the indicia of, essentially, Your Honor, it's because I don't think he was keeping his time close to the time that it was approved. He wasn't sending invoices out monthly and that sort of thing. I think this was it appears to me this is manufactured kind of at the end, but I don't think it's going to qualify as a business record. Now, again, I don't know that he's going to admit it as such. If it's, something that he would use to refresh his recollection, I could understand, but to replace his recollection.
Okay, so in the interests of efficiency here, Mr. Hidari, would you anticipate introducing any new exhibits in phase 2 of the trial?
Your Honor, could I speak briefly just to the point that Dylan just made? Devereaux,
Mr. Howard, you mean?
I apologize, Mr. Howard. Devereaux specifically talked about what is he?
All right, let's go back on the record if we weren't already. We'll table that and we'll see what we got. I think I've been handed a question, which I'll mark as Courts Exhibit 4. It's kind of hard to read, but I believe, I don't know, counsel can come inspect it, but does the absence, and then it says 3000 Old Alabama Road, Suite 119, Alpharetta, Georgia, and the zip code, circumvent the mail from being delivered to the PO box, does the absence of the physical street address mean the address is incomplete? So, anyone wants to take a look? Here it is, tendering that for the record. And as a response, I would propose writing back a note that says the evidence is closed and the jury must rely on the evidence in the law that's already been presented. Okay, a piece of paper. No pen letters of move. Yeah, just tear off. Is there a request, whether I say this to them in person or whether I can send them back a note?
Just put that on the record, if you're not sure of it.
That's good. So yeah, how about I'll write that on the bottom of Court's Exhibit 4. All right.
Your Honor.
Okay, so again, for anybody's inspection, I've written the evidence is closed. The jury must rely on the evidence in law as previously presented. All right. Hearing no objections, I'll send this back. But Deputy Scott? If they have another response, you can bring it. Okay, turning back. Sir, I believe you had something you wanted to say more about Devereaux. He's taking it. Okay.
Sure, Your Honor. And to be quite honest, I don't even remember the question that was posed before.
That's a good question.
Something to Mr. Howard's statement.
That's correct, Your Honor. You had asked if Mr. Haddad was gonna offer.
That's right. Documents and evidence. If you were going to be supporting your testimony with any kind of documents, we were touching.
For attorney fees?
That's right.
So, yes, what has already been tendered in the pretrial exhibit and provided to the other side.
The one that he's referring to.
Yes, that,
You clarify which that is, because there was an exhibit and then you sent like another document that you said should have been appended to the exhibit on the day before trial.
there's the fee agreement and there's also the ledger. So both of those documents.
What was the second document?
The ledger?
All right. And so I take it, I haven't seen this document, but it sounds like Mr. Howard anticipates making a hearsay objection to this document. And so what would be your response to that?
There's at least two. One is it would classify as a business record because I did in fact enter those things contemporaneously. But two, I have personal knowledge of each and everything on that ledger. There's not anyone else's work or anything else that's involved there. And then three, when you're talking about Devereaux, you also don't even have to, I'll just quote. The other side was objecting based on the fact that they were broad summaries of work performed and estimates of time spent. Mine are not broad summaries or estimates of time spent, but even in that case, the court came back and said that was sufficient to demonstrate the reasonableness of their fees. So.
All right.
Different question, Your Honor, that if Mr. Hadar was just purely arguing that supports his 40% attorney's fees award, that's what Devereaux stands for. It doesn't allow you to use general summaries to go back in and prove what you've really spent or what you've really incurred because suddenly you've changed your mind and you want more than the 40%.
Okay, tie this back to the rule of evidence we're debating here. Is this back towards business records or now you're making a general relevance objection?
I was just responding, Your Honor.
Okay.
I think it's irrelevant to what we're discussing. I agree with that.
Okay. So, but to the point of the business record, I think that's something he is going to have to prove is I think those three preconditions of whether it was made contemporaneously and in the course of his regular business. And so granted, if you're able to establish that it was not, then that could be a sustained objection. So I think we've at least clarified that. Anything other than that ledger / document?
Slash the agreement.
I suppose, yeah.
Those are the two for attorney fees.
Okay. And would the defendants anticipate calling any witnesses at phase two?
Attorney's fees, I would not anticipate.
And or punitive damages? I don't know.
No, Your Honor, you don't anticipate calling any witnesses.
All right. Okay, I think we've covered everything we can. Let's go off the record. And we'll await further direction from the jury.
Your Honor, just for clarification, when we do get to the punitive phase, I'm the only one for attorney fees, but I would call my witness for the punitive aspects as well.
You have other witnesses for the punitive aspect of it
Well, my client, I'd call her to the stand.
in order to cover kind of what grounds?
Basically, what we're seeking and why.
You would object to that, Your Honor? I don't see how that's pertinent at all.
Okay, well, we'll put all this back on the record if it becomes necessary. But what is it she would be saying in addition to what she already testified to?
Well, specifically, there are some records provided by the other side that she has knowledge of, and she'll be able to put those into the record, which I think will be necessary in terms of establishing their motivations, whether they're acting with a conscious indifference to consequence, whether they're acting with an actual intent to harm, and their motivations and all this. The purpose is to punish and deter. And so that's what she would be providing information about.
And what are these documents?
Specifically, the trust documents that the other side has referred to, which indicates how this thing is operated, why her house basically got transferred to a third party, and essentially the value or the amount that would be required in order to deter the defendants. Because the trust identifies how much money we're talking about.
The trust that the house was eventually sold to, or break that down for me?
So there's this GSR document, which according to defendants is a trust where my client's property was transferred into. And when Wells Fargo foreclosed on it, they foreclosed on it in her name. Later on, they came back and said, no, it really belonged to the trust. It really should have been a trust that did the foreclosure. We were just the administrator of the trust. I think the value of the trust is very important in assessing what amount would it take to deter, to punish, and basically make sure that this doesn't happen again.
Okay, all right. Any particular, let's go in order. Mr. Tobin.
It sounds like Mr. Adair wants to introduce maybe a couple thousand pages of documents into the record and have his client testify about them. We're talking about a mortgage securitization from a couple of decades ago. And yeah, there were thousands of loans in the securitization, so I guess the overall value of the securitization was a lot of money. But how that bears on punitive damages in this case, and how in the world plaintiff, Ms. Zong, is supposed to testify about 2004 securitization, it's not relevant. There's no way she's got any background or foundation to be able to testify about it. There is a punitive damages cap in Georgia. So why we're talking about a 20-year-old securitization that had tens of millions of dollars in mortgage loans in it, I mean, it's just way beyond me. So I think that'll be objectionable, and we certainly would object to its coming into the record.
Okay.
I would agree with that, Your Honor. I think it would be incredibly prejudicial. As Mr. Tobin said, the value of the trust is the aggregate value of thousands of unrelated mortgage loans. And I don't know how that would necessitate Ms. Zong's, I don't know how you would call Ms. Zong to testify to a trust document that she didn't create and she's not familiar with anyway. But no, we would object to that coming in at all. I think it would be prejudicial, confusing to the jury. I don't know what it was.
Okay. All right. So I just want to make sure I've got it all covered. Ms. Zong would come back to testify about trust documents. Any other documents?
That would probably be the only document that I can think.
Okay. And so,
She'd also testify as to what why she wants to punish and deter the defendants.
all right, that wouldn't be relevant. I understand. I think that's something you can make an argument, just like you've done before. I think her personal opinion on that, I don't see that as being something that needs to be factually admitted. Okay. Anything else?
That's it,
All right. All right. Well, I think that's helpful.
Your Honor, just one more point I wanted to bring up, which is you're talking about the 250.
Mr. Tobin, I know it's been a long week, but we got, come on.
Sorry, I did swear, Your Honor, and I regret it. I apologize.
But even then, I mean, if we get to another closing round of argument, he has the right to a lack of audible distractions, right? All right, Mr. Haydari.
Thank you, Your Honor. Mr. Tobin was talking about the $250,000 cap, which doesn't apply if you're seeking or if you demonstrate that there was an actual intent to harm. And I do believe that jury, we specifically requested an instruction on that basis. And I do think the evidence is sufficient to show that PNC did act with an actual intent to harm my client.
Well, all right, that might be something.
There might be something to be decided on directed verdict. We do have a motion that's pending. And perhaps the court could consider ruling on that before it becomes right.
Right. Okay. But in terms of that distinction between want of care and intentional, I think that, I mean, that distinction wasn't made on this special verdict form. So the jury's either going to be saying thumbs up, thumbs down.
That gets decided in the second phase. Whether or not there's punitives is a question for the first phase. Whether or not there was an actual intent to harm that lets you exceed the $250,000 cap, that's always the rest in the second phase.
Okay.
On the verdict form.
Yeah.
We don't have the second phase of the verdict form, Your Honor. So
We haven't confirmed one, no, but what I'm hearing is if it does go to, again, I know we're just talking hypotheticals here. If it is put to the question of for either party of whether the punitive damages should be allotted, is it the position of the defendants that there should be no distinction between the two alternatives about, what triggers that cap?
No, there's definitely a distinction between the two. I haven't heard any suggestion that a question that would qualify him to get above the cap be included. So my understanding was that we were just sort of focused on the baseline that would get to at the moment. So this is the first I'm hearing this request for an additional interrogatory.
Yeah. Okay. All right. Noted. We will await direction.
You command attention, you know?
like, will you be ready to question? Sure. Make sure you hit all those questions.
Will you give me a face? I'm just gonna get clean, put on mine, I'm gonna go back in their rooms. Would you please just send me this to you? Just like I'm clean, just attach an email and stuff.
Yep, I got you. Thank you. Of course.
Sorry. It's hard to be calling. My wife's name is.
Oh, I didn't take it.
Yasha, would I need to share any exhibits when you're?
There's just two that need to be shared and it's not gonna be a big deal. You can do it from my computer.
I'll need to use your laptop.
No problem.
That everybody built on. Statement of fact. It's like a. It's perfect. Yes. You think that time that.
Yeah. Unless there's a big surprise, but yeah. I'd be shocked.
You're in courthouse? Yeah.
Not quite as good as the courthouse.
Again, they could use a mess.
You got to recheck.
Yeah, I didn't reach on this. I'm hoping that it's like, you should travel.
Yeah, I was there. On the south side. Trying to remember, there was like another hidden entrance to security that nobody's even know about, where you like walk right through. I think it was on the south side, checking in. The south side of the airport. As long as you go in that direction, my tickets from the ticket counter.
Yeah.
There was, opposite the ticket counter, there were stairs down. There was extra security there. And I just walked right through because I got lucky. You came in that way. Okay. So if the regular ticket looks fine, yeah. I would.
Did you walk downstairs?
Yeah.
That's later or.
Was
Oh, was it?
Yeah. You know, it might not be, that might have been temporary, maybe people discovered it. So there's some of the,
Yeah.
it looked up there.
Okay. Yeah.
We usually appreciate it.
Yeah, and I'm gonna give myself a little time. Apple's got it, so not. Check my bags.
Yeah, of course.
Get slide that through. Security and that'll bring with it.
Yeah.
Let's try.
Yes, right. Oh, we already know this, but he's the judge for Fargo. Yeah, he's nice. He's the judge for a case. Oh, I forgot. He's an attorney in his house. Which I know. Yeah. He's the judge for that case. Yeah. He's a good judge. He graduated Harvard. He's Harvard College and interesting career choice. Yeah. What do you think, sweetheart? Yeah. I'm trying to hear you. I can't hear myself in there. See, is that it's very thin. Right across the- Oh, it's right here. I'm trying to change. Does that make normal? 9 more. What was that? Oh, shame. We got it.
I want to tell you, I don't know if I'll have an opportunity to tell you, but I don't know how all this is gonna go. But as a mother, you need to be very proud of your children. You have very excellent children. And that's the most proudest thing you can have. You have a son who went to Georgia Tech. He does excellent. He's extremely smart. And you have a daughter and a niece that are equally as talented, and they're healthy. So I need you to focus on that no matter what happens today, okay? They are beautiful, and that is your pride. That is your legacy. That is what you need to bring. Everything else, your cars, the houses, everything else goes. But your children stay on, and they will pass on your traditions. So you need to be very proud of that. And don't be sad anymore. That's so joyful as a mother. You have accomplished so much. Your children are your trophies. I shouldn't tell you that. I'm sorry, I'm drinking tokens. I've got so much right here, but I wanted to tell you that.
Every moment when I think, when I heard that, it's just my would poke by the knife. I'm so glad I have this day so I can let this out. When my daughter saying went to Georgia, it just that I have so difficult.
Well, when I look at you, I see a very, very just fortunate person because of your children. And I just want you to remember that and hold on to that, no matter what happens here today, no matter what. You
Thank you.
have trophies and you go from here and you go on, no matter what. Positive, whatever. I think your counsel has done excellent work for you. So I have no issues there. I think he's done great for you. But I just wanted to tell you as another mother that I saw your children not testifying and, your niece and stuff. And I just thought, oh my God, she's just so fortunate. Some parents don't have that, And so I just wanted to tell you,
Thank you. I should give you a hug. Thank you.
Thank you so much. So, I shouldn't have so much of this food either. I made your client cry,
Yeah.
telling how she's so fortunate to have such great kids, Um,
Was it where? I have a few options. I like Decatur Square. Yeah, yeah. And I just want simple medium. And kind of rains. Yeah. Like, music getting married, you didn't get your license or? Oh, okay. That's interesting. Yeah. Well, I'm sure I can see you guys, so your connections there's a ton better. Yeah, you have the paper. I haven't seen. I do want to. I don't think. And if we get married, and it's an in terms of the visa, it's an extra safety net for him. Be my spouse. Yeah. And I actually want to show you my family. I never showed you my family. Before my spouse died. So this is when back in Hangzhou. I haven't in Hangzhou. So that's my dad and my mom. They're in Vietnam. They live in Vietnam. And was my maternal grandparents. I'm super close because I lived in their house when I was very young, like infant. And my grandfather, he's a mechanical engineer. Yeah, he was still working until like 2 years ago. He's a workaholic. Yeah, and they, they both went to Xinjiang, Xiaxiang, and they got sent to like remote parts of China to work, and then they came back.
Like my age when I graduated.
Yes.
That's the time almost. I just,
Yes. So they needed so the Chinese government wanted to develop like Tibet, and she also sent local. They're Shanghainese, like local people in China, and they got sent to like remote areas. And my grandma was a mapper, like she drew the maps. She worked cartographer in Xinjiang, kind of one of the first people to develop that area. Yeah, and she's like one of the most independent I've met. Even now, she's almost 80, and she would go on girls' trip with her friends. Yeah, and this May when I was back in China, I had this what I told you. Oh, I love it. This is me. Thank you. See if I can find the actual. So that's the resort that I talked about. It's kind of Lake Lane, it's like Lake Lanier, they built a dam around it, so it kind of became a water reservoir for Shanghai and the provinces around it. Yeah, that's us. Yeah. It was hard, can survive in the grandparents to Xinjiang. Yeah. That time, the situation in really bad. Yes. My grandmother wanted to go to high school, but she could not because there's no money. So, yeah. And when we got back, my mom booked the first class on the high-speed railway, 高铁. Yeah. it's like first class on the plane. But yeah, we have the entire cabin to ourselves. Yeah. So they have like 5 seats. No, there's 5 seats and that's the entire cabin. The entire cabin to ourselves.
Okay, Scotty, y'all the only court still up. Everything else is down. What time? Yeah, all the inmates gone. The only one still up. How long you gonna look?
My not official, yeah. Not yet, but we'll be having that talk.
The only one still up.
He went on Emory Law a couple days ago and see that? That's me and him.
How long they been deliberating? Where? Civil case?
Oh my god, what? They from? Or? Okay. This one there. Tell me how better one the glasses out. Then maybe he could say Ray, I guess. He's tall. He's tall. Yeah, that's him. Did I tell you he works at the veterans clinic? As a veteran clinic. So there's a veterans clinic, law clinic at Emory, so they provide free legal services for veterans, like military people. Just paralegal. Paralegal is going to work. Oh, that's different. That's different. But those people, they were like former US soldiers. And they came back and they had benefits problems. They believe that they are entitled to certain benefits, but the government denied. And my boyfriend's job is to kind of argue for their case. A lot of veterans, they don't have enough benefit. Yeah, a lot of times they have some, impact. But they, after retire, they need to have treatment. A lot of them have PTSD. Yeah, it's very common. Yeah. And that's my cat. I know. That's Vicky. You look naughty. You have a long cat. I have two cats. I see little. Oh, you same thing. You have 2? I have 2. Yeah. So did you also have like a formal wedding ceremony? We only have like a court ceremony. Like in the like in here.
just missed lieutenant.
Huh?
He missed LT. He just went through there.
This is my WhatsApp.
Don't tell me what up.
Oh.
You know, what up. Oh, yeah.
This is your.
This is good. It's got stuff.
And this is your mother? Oh. Is she here in, oh no, you mentioned she's in Miami.
She lives in Miami.
Okay.
Here's, that's me.
Oh. Oh.
This, my sister and my husband. And Puerto Rico. Puerto Rico's, it's, in Dallas, Maine.
Oh my god, it is so like
Weird.
just seeing Yasha in long suits. It's weird. Is that your house?
Yeah.
That's big. That is a big house. Yes. It's so funny seeing Yasha like right now.
It's actually, I think, what's that? Magnolia tree. It's not so long.
Do you have like a big backyard or front yard?
Mhm.
Wow. You picked up the. Oh, it's her birthday?
Well, my brother's mom.
Oh,
Yeah.
yeah, it just look at this look like.
The cake.
So this is like your kitchen and then dining. Oh, I love the setup. So that's is that the
It's very modern.
so, like where it leads outside?
Yeah. This is just a view. There's two.
Oh.
This used to be a wall on the house. Inside the middle was like a different room. We opened it.
So yeah, like an open concept.
Very nice. Very warm.
Yes, all white.
This is anything like that.
Did you design?
The kitchen, we did the whole kitchen.
Wow.
When it comes to the things, we kept kind of the same, but this kitchen, we redid everything.
That cake looks delicious.
Yeah. It was chocolate. I like chocolate.
Oh, you don't like chocolate?
I'm not a big fan, like, sometimes I'll eat it, but my sugar loves chocolate.
Yeah.
Loves. Okay. I like the fruity stuff. Nice. I love those flowers too, when it's just their home. I think they want to encourage me to some. Do we have to change the phone? Oh, you know what, I probably don't save. No. It's my uncle, he's a famous uncle. He was, this is my grandfather. He lived to be 100. He's still,
Is that a giant cactus? In the back? Like where is
yeah,
this?
this is Peru.
Oh, okay. So is she now in elementary school?
She actually did she had kindergarten
Oh,
because she was born early.
oh,
She was
okay.
born on the last day of May.
Yeah,
And
you didn't go longer to rush.
I don't think she was this my niece. So my cousin, who's like my age, we were friends. That's his daughter. And she's doing traditional Peruvian dances with the traditional Peruvian clothes, but she's in Canada. So
Oh,
I think his wife, and cousin's wife, was, I think she's half Japanese. The culture. When you come to the big party is like the internet. It's like family. It's my uncle and aunt. She's the youngest. There's six brothers and sisters. Who did you want to see? Who did you want to see? Yes. You have a sister. Yes, essential. Yes. And her husband is also a Chinese. Yeah. With my daughter. This is my first baby. Yeah. So far, you get together just talking about what the book. She goes. Oh, this is a. So we'll just send you this picture.
oh, yeah.
This is
This
when we
place.
went to the Supreme Court. This one would come down to get me.
Steve.
Yeah, my mom too.
Steve is nice.
Yeah. There's one happy.
Yeah. I know.
This is my in-laws house. So this, and this, now she's sister's kids.
Oh, she has 2 kids.
And so she's the oldest, and then, yeah. 3. Well, this is Eric. Sorry. Same thing is, I write the house, it's kind of like, okay.
Me too, me too.
Their house is really big.
Oh, you're sure as dad.
Did you keep the first key? I did. This is my aunt. She is my dad's twin sister. Okay.
So when you both are in courtroom, who takes care of parents?
This week, she took on this week, she's in school. Mom is at home. Mom came to answer. She's still in help.
Okay.
And then now she's mom like picking her up and taking her to run.
Oh, okay.
So everyone's looking.
Yeah.
Yeah, she's parenting also like making us food.
Yeah.
This is also my Switzerland. There's no king in the triple box. This stuff, but he's not even. Oh, shit, no. That make confused, that's close. Yeah. There's a lot. Yeah. So daughter is kind of getting in. She's the youngest one. The sister. Those are the older two. One of them is 17. Okay. But who's taking care of them? You know, to take out. Side. My, yeah, she's just regular working. So she can take, she takes care of it. She's not working. That's nice problems to be out. Now it's like a botanical garden. A lot of tropical plants there. That's what rose and we see a lot of bees. Because it's very hard to get the bee. And then there's a lot. Yeah, I like a small pot. There's nothing for me. And I put the goldfish. You know the one? Goldfish. Oh, yes. They told me need to have the pound. And there's no one kid get it. But then I said, no need. There's a lot in the pound. And it's hot. And then it comes that's he get it from. A lot of nice kitchen. And the laws. Like when you think about having kids, have you ever like is that an easy decision for you? Or you do okay, because I just that's like the way. That's exactly no. Unless they call them to have kids. So it's like before that somebody were waiting out or I just really wanted to be like okay fine. Not because I wanted to but because they kept asking to me and it's about setting what like setting the net. Oh yeah. Why would I want to do that? Yeah. They'll make their own money. Now it's so expensive. It's so different. Yeah. Of course, long everything for us. Yeah. But we didn't want kid. And it's not that we were like, oh, I don't want kids. I was just like, I don't feel like having kids right now. I have no desire to. Yeah. And then actually his sister was like, because we always thought that my parents and we're gonna try to have kids. Yeah, and then obviously
Oh, but she did. Yeah. Well, she will. Yeah.
I think she already paid.
Then you can't wait. Yeah. Yeah, you told me, yeah, about the acupuncturist. You told me about the acupuncturist and, right, and then after you also got wolfskin, yeah. Yeah, that's good story.
But I guess my name was, when you get my name, so you didn't.
In go, there are challenges like come my mother. Faye is like, yes. Yeah. Exactly, yes. Yeah. Takes all of us, huh? You know, I feel scared. Yeah.
I can become normal. They trust not to it's only the teachers highlighted in municipal school. For me, we can be manager. Jason's almost. I help him to break down because it speak that did examination. It involves he knew how to look and forcefully he can and have sick mentality during the Friday the test. And at the beginning he fell and then he cried. And I said, why is so difficult for me? I said, it's very easy. I said, by Wednesday, 3 to 4. And then Thursday and Friday night, Friday before you go to school, then you back to normal there, and then it's I don't know, one day.
Ready?
Yeah, just coming out. Oh, the rest of the bottle, no. Yeah.
Will you be able to
What?
build the
I
secret?
didn't have a question.
Okay.
Come to order.
Like, in this last year.
X5 is, Hartford is Plaintiffs X5. People are not options, yes. You get Virginia. Yes.
This one.
263?
And this.
It's fine. Okay, yeah.
We're not there yet.
All right, yes, okay.
You guys can switch back.
Okay.
I know, well, I know, just in case. All right, Mr. Ferry. There's plenty of papers. And it'd be like.
I think we received an email, Your Honor, so I wasn't sure something was going on.
I just got it a minute ago.
Oh,
So no, we hadn't sent out an email just yet. But if you happen to know, Mr. Tobin's in the hallway.
he is, he's not right outside, but he's very close.
All right.
He went down to get his suitcase.
Yeah.
Your Honor, depending on how this proceeds, is it your intent to just go jump into the witnesses immediately or to send them back or what?
No, we could break for a moment to discuss things if we need to. I think everyone needs a chance to digest whatever. I mean, it's not a verdict form, it's another question.
Oh, it's a question.
So,
Okay.
you know.
It's my RM Williams boots.
I like them.
No, handmade no.
Thank you. I got excited.
Your Honor, I wanted to tell you too, I apologize to Mr. Howard. My wife's name is Dylan,
You don't need to apologize.
so I keep referring to him as. Not great for us. No. So I should say the same question. Yeah. Yeah.
It's sweet, but you can go check it out. Yeah, no, it's Mr. Isis. I'm sorry. Yeah, you're so sweet. No worries. Yeah, Richard. What else?
Yes.
Do you speak like Spanish, like all like a lot? Do you know how to say jurors?
Jurados.
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 Los jurados. Los jurados.
No, no apologies. I don't think we emailed you. We just got another note. We're ready to go back on the record. Been handed a few minutes ago from Deputy Scott, another question, which I've attached and will tender as Court's Exhibit 5. The question reads, can we find the cost of lawyer fees, parentheses for Fei Zong? And my proposal would be to write on the bottom, please complete the verdict form as provided should you reach a unanimous decision. The amount of attorney's fees, if any, are not decided at this juncture. It's a proposal. If anyone's agreeable or has suggestions, that's where I would leave it.
I'm agreeable with that, Your Honor.
Sounds appropriate.
All right. If anyone wants to inspect it before I send it back, did we get number 4 back from them? Yeah, if we can make sure we do that. All right, then I'll send that back. We'll be off the record.
Has any questions for attorney speaks? Would you look at it? Just let me know your thoughts. I'll send them to you.
Yeah, that'd be good. That one and number 4. We'll remain in recess.
They're probably close then. Exact wording. The question is. Could be. Yeah. It is still.
We're done.
Yeah, just. Not that. There's no. Yeah. Yeah, see, that's what I was thinking about. I was thinking the same thing. I should. Do. Just. But. Whatever happens. Honestly, that's very. Thank you. Thank you. Yeah, it makes me really happy. It's true. 100% the trees. Oh, cool, yeah.
Not right now. I will ask a question.
No.
But there's one for it. Like one resident there, and some of them in Chinese is Shun. It is actually sounds similar to our So I asked her to check. So this is. Yeah. Came up with. So the second, this level means really spiritually. And the third one, so that actually means like common, but like not in negative connotation. It means like a lot of people have this in their names. It means like a good wish of not too much ups and downs in life. And so moderation, yes. And that intonation, because it's the second intonation, kind of balances out the first two. So this is, so this sounds like show me. Yeah, because we're. Yeah. And this reads like that. I can encounter Chinese and. Oh, I just feel. Feeling the toes? No. Yeah. Yeah. Show. Yeah. I think that's your last thing and your first thing, and I have the rest will bear. I can text you the name and then you can like.
You have my number.
I don't have. And you can like type in ChatGPT app, like give you like different variations and like different. Other.
Do people in China? I know in Japan, they're very drawing like characters now. It's fun.
Yeah.
We want to do that in China.
For name?
No.
Well, yeah, for well. In terms of like decoration.
Like the.
Calligraphy.
So, okay, you have your chart, yeah. It's about there.
Yeah. Yep. Right. I guess I tried. It only has more than that.
No, it has to be called. So great.
There you go.我是我们的 AI。I asked ChatGPT to think of the names. Yeah, they come up like this, and then I asked like follow-up questions to tweak it, and then they come up with it. I really like this one. That's very cool. Yeah, I know you have it. I tried, but I haven't really tried. I don't know if you saw. Yeah. So that house that we live in now. Oh, because it's split up. Okay, so because we were coming from a very simple. And so our condo was so small. But when we were huge for us. Yeah. And so I was a journalist. And I was like so sick of it. It was just so much. It's stressful.
I closed the bottom floor. I was gonna put a wall in the door and I closed it because it was open. And so I closed it. And I imagined it's just like this in a year. Woke up to the bottom floor and the president. And so we just been hanging out.
So now it's still leaving.
Yeah, so now we're gonna do.
Oh, like the bottom.
So I asked, they wasn't chat GPT, it was a WhatsApp file. Have you seen that one?
No, I only use like the visual chat.
So see, like,
Oh, you asked me to design.
show me a picture of the lady. Picture. It gives me one.
I'll figure it out. Yeah. Makes sense. So since this isn't ChatGPT, the visual one,
Yeah.
so.
And you think that one, the other one would be better?
So the real ChatGPT is actually very, very good. But if you want to use the picture function, I think you have to pay to use their like upgraded version.
Very fun, I just lie down on the benches. I'm so tired.
If you hang out.
If this is a game away. Or like snack. No, I've got that big keto, yeah. Sorry. Yeah, it's a 3-day holiday, right? Yes. Monday? Yes. I was gonna ask you, what happens when they don't reach anything? I guess I'll figure it out. Well, no, I'm going out next,
That's what we
next
like,
week, but.
use the same.
I need that for pizza. Is he in the Plaintiffs though?
Yeah, I'm just gonna catch up
person
on
who-
work.
The fortune teller.
The Tuesday, so. Yeah, but I have to come back 10 years ago.
Okay.
Yeah, sorry, I don't mean to be so driving right now, but. I never get to sleep last night. Oh, no, I wish there would be. Yeah. Say, lie down here, on the other stuff, it's- I just need like one of those power. Well, I was gonna ask her.
What?
No, I just thought that was an interesting thing.
Sean, fun. Fun? Fun?
It's.
Never about that.
From.
That's
You
okay.
texted me from your Apple ID, by the way.
We only have.
It came through as Chindu 96 or something.
So. Well, one more hour.
I'll just text you my number and just save it. I don't know what.
I go back in the corner and mess it in, but I'm like, yeah, I can bring one. I'll pull it in the back. Oh, okay, thanks. Thank you.
Except. It doesn't mean, somewhere they don't nice, but just among person, the concept.
Remind me of the first question.
Oh.
The address, no, I'm sorry. From the jury.
What?
New time.
From the jury. Failure to include the street address, is it rerouted?
Does the absence of the address means the letter is sent to you?
Yeah. Does it, like, is it incorrect or something like that? If you look at them Zoom and if you find the time, there's a transcript of what's being said.
And what does it say? Evan is asking. What timestamp are you at? Negative.
19.26. That's the grid after you send it.
No. Is it? Oh, wait. Bucket. Yeah, I like settings, please. Okay. Okay. So you have to go feed it in. So we have two different garbage. And I see the and it's too full. Yeah. You just like. That's important. That's very. But it's still very like more expensive. And that whole.
Because I don't know. Since you're still in.
Yeah.
Because all I know is on the call, they would down the teacher maybe something, which is like, it gives them 2 weeks to
Okay,
people who do have license,
okay,
okay, basically, can break them,
okay.
so. Okay.
Yeah.
So we.
Yeah.
We were always just struggling around here. You know, you're just like, this is probably. So we were. On the
In
other
between.
side, you know.
Yeah.
But
Yeah.
since then, the enemy had to come here, his family, that was just standing on there, and they look at the houses. It's just, it's kind of crazy. We got one.
Yeah.
We were just like.
When did you buy it? Buy it? Your
2015. 2015, I think the house. And the airline.
15, 16 is the house, and then right after that is 15. And after, not really, it is kind of coming back. The saddest things for me is all this after that, the 10 years that is lost. I have no chance to do it. Yeah. It just a beginning to coming back, and until the pandemic, during that year, that is not the real estate is so good. Been very good. Now this year just down.
real estate during COVID is cool?
Yes.
Why? I thought people were not.
No, at the
buying
beginning it's not, and then after that, and then the people from San Francisco, the big city, and then
Oh, yes, I heard that
yeah,
too.
and then they
Yes,
just moved. And
yes, yes.
the house there,
Because they were rich.
yeah, it is.
Yes, I had a friend move from Irvine, California to Atlanta, and it's one day I was walking Beltline, and I just spotted her, because we went to the same college. After all these years, I saw her.
In China?
No,
Oh, in California.
In California, yes. Yeah, yeah, but I did hear a lot of people moving to Georgia, Florida, and South Carolina. Yes.
Also because they have the law, they have a stricter law.
Yeah.
Yeah.
Yeah, I just remember the first 2 years of COVID, the rent went down a lot. Yeah, because nobody, from Emory, it's remote learning. So a lot of students just didn't no longer have to rent. So the rent just went down.
There is a very short time,
A very short time.
and then the student move back to stay with the parent.
Yeah, because they didn't have to
After that-
come.
After that, and then it's kind of crazy.
My 2-bedroom, 2-bathroom apartment in Midtown is 2,800 a month, and it always says it's only expensive. We plan to move back to Decatur after this year. Yeah, I like Decatur. I know Yasha hates Decatur, but why though? You just be exploring?
No, I think it's long. I don't know.
You don't know.
How it's very like the British.
Yeah. To such
I know.
extent, yeah.
It is,
Yeah. Okay. But I like downtown Decatur.
Yeah.
Yeah.
Do we still have that like restaurant? It's like 3 or 4 for It's in the.
Yeah, yeah,
That's
it's
my favorite.
Italian. Really, I like that mushroom too. Yeah, Midtown is true. It smells. It's exciting to live in Midtown, you know, with all the things happening. In Midtown.
We were 2 in the morning. We were night people.
Yeah.
And then it was, you take the change around. Completely. I didn't know that at all. Like, basically, my job would change. Like, what I was doing every day would change. Like, I mean, like, I understand it was a big change. But I didn't felt that would change.
Like your personality, like you're a different person before you have Aries.
I think it's like a huge change. All of a sudden, first of all, I was very physically healthy.
Yeah,
And
that's what I worry too. And you just.
I'll
It's
tell
just
you,
very
I got
challenging.
another thing like this on that earth, and I would do,
You
I
have what?
would do.
With the.
Small,
Is it a
it's not
C-section?
a mid one.
Oh, okay.
Okay, but she's like mine, she's private.
Okay.
Not to go hospital, but well, I think go to the hospital
Oh, you
because,
asked me.
because I had complications, but like I had it private,
So not through a hospital.
not through the hospital, but like between also when you go to the nurses. So that's doing now, she got this. There was like these layers and pressure things and shit. And like, the nurse puts
Yeah,
the
yeah,
bottom, so
yeah.
the lips are not dry, she's in calm.
Like a personal assistant.
And she's in Twitter, she knows that I had unmedicated childbirth.
Seriously?
Yeah, and the nurses was like, this is the best birth I've ever seen. You know, it was amazing. And I felt good. I was like, it was wonderful seeing him. What nurse's sister? She had travel experience.
Okay.
And I spoke to like other, at that time I had a lot of gun friends, so they told me about their life. And like they had gun experiences too. And I was like, I have a lot to have a gun experience. And I did a lot of research and I don't know, folk. If there's some books in particular that I was reading, like, made me feel like empowered about it. It made me feel good and confident.
Okay.
And after doing it, like just the stuff she was doing, it relieved
The
the
pain.
pain.
So you did not have the anesthesia.
Nothing. And I was like, I don't want to do it. And if I ask for it, then
So it's a pain, but you
Yeah.
just not use
because you don't have to do like I don't even if I stand like no. I was open to it. And I tried to do it. And I feel really
Okay. You are the first person that ever talked to me about it.
And then, yeah, and the way I can like the, I've been thinking that this I happen to understand is develop reviews for the company.
Yeah.
And it is.
So you found it with a Yelp like company.
I was looking at something else, and somehow it was came out.
Never heard of. It's
I'll get information for you, but I don't know.
maybe in a few years.
I'll just like bookmark that. Like I don't know now, but maybe one day. And then so when the time came, I wanna.
Yeah.
And I like,
That's so
It's just,
cool.
it's worth.
Everybody.
Such a wonderful experience.
Yeah, you are the first person that I've ever.
A friendship there. Who's gonna be close.
I see. My cousin.
It was late. Right? She
was
was
like late.
coming in. They were trying to get her to come in, but she wouldn't, she went up. Because it wasn't in her real job, it was just like whoever was on rotation,
Oh, okay.
so it wasn't actually open, there's exactly. So you want me to get her in the back of me down. But that is not the way that you're. Sorry, okay, so it's not the best for you.
Okay. Okay.
But it's the best for the doctor who just, is like, it's the easiest for him. It's not the best for you, because that's not ours.
Okay.
And so, what we do, what we do, try to basically make squatting or help with the.
Yeah.
And then like, all hospitals, they have a couple options before that.
I did see that on television. Yeah.
Because the ones that they don't tell you, we all have some shit that they don't tell you. Like, you have
Okay.
Also, what is, they have a few later.
A wireless. Oh, my.
And it's like, these are things that, and then that's for really that person's.
Yeah.
And sometimes they do. And I'm just, I'm trying to. I didn't say that, I was just like, okay, I'll try to move. She knows it.
Yeah, she's experienced.
We're gonna do it, but.
Amazing. Yeah.
Oh, she's not there.
That's why I want to.
The other day when I tell her, and then she says she's not ready, and then I just kind of, sometimes we have something in mind, generalize people change their mind, time to come.
Me too. Yeah, me too.
Yeah.
Immediately, I'm going to do it all. We did pass the consider. She told, she told my mom, go up, communicate with the power on the coast. And she's like, okay, you can do it in front of the whole. That's not what you can do it in front of the whole family. That's not what we got involved. Wow. And so they did that.
Well, he did that.
He did it, yeah.
Okay.
And so we were engaged with the and very. Right, yeah, I mean, we did, and I was also, don't know it, because I'm like, I'm not. Right.
Yeah, yes.
And then he's like, do you have any food in the The first one has 7 stitch. With our, without the, yeah. That's what's the most, was that on, she was, yeah, my, sister, she was, she died.
No stitches for the C-section?
The family tear.
Oh,
Yeah.
yeah, she's also so even natural
Yeah. Big can, so they, at that moment, it's the season just cut. And then later, I just stitch. Every single stitch is kind of like a screaming thing for 7. So.
But you didn't have to cut the stitches. Okay.
But after that, you still feel happy because all these things you have to
I
feel.
don't think I'll be.
No,
happy
they-
after this.
Don't say that when you're not in that shoe. You can say.
I mean, it's amazing.
Because of the baby.
You can get so. It's just
Yeah.
amazing.
Yeah.
Someone, you're inside of you.
Yeah.
You procure everything for them, either her, either Julie. Come out and she's like, you did that. It's like,
That's
oh,
true. Yeah, that is true.
After that, people they say, oh, I prefer just let the baby come, sooner and then easy. And actually, in my opinion, after that, and then when you pregnant, the people have a lot of symptoms. And I said, that's this time is better than waste them because we don't do something according to the law and then we take them back. As soon as they involve, you need to pick them first. But when you're pregnant, you don't need to. You just decided what you want to do, just only the food or be careful and make sure it's safe. Yes.
We had $2 cash.
Yes.
Yes, yes.
So I just need to print out, that's all I needed.
Yeah, my mom, going to a place called profession. Yeah. Yeah, that's a really cool. Yeah. Just a lot of medical conditions. She was sweating the entire night. And today I'm honestly still seeing. Even today, some of that medication still affect her. Yeah,
That's, I mean, that's a lesson for you, that you can keep pushing yourself. Even to, until it's too late, until it's too late. Listen to your body, respect your body. Don't push yourself like that, because I feel like that's what you kept pushing and pushing.
okay.
There's nothing more to go. Kept. I mean, more socialities. No, that's something I have forever.
It's not,
Conversation. That's not good.
it's not,
It's not amazing, but it's because I got it from
okay.
and so I'm just like losing one from one.
Okay.
And so it's like it gets worse. And the only thing I can do is stop it from getting worse. But
Okay.
it's never gonna get. It's not gonna do it.
Okay.
And so that's sometimes I feel like it's a bit too much. I think I feel bad. Yeah. But like I had to learn that lesson. You need to respect the learning stuff. Not listen to yourself, listen to your body. Like so tired, don't keep pushing yourself. Like sometimes you eat so much that you don't even hear your body. You're just like automatic.
I think that when you write it, you make it all sound cold, but that's, okay, I may have to check my two reactions. It's a good, yeah.
I'm calling.
Nope.
No, that's not people watching.
I panicked a little bit because I thought I turned on. What are you doing?
What's up? Look very happy. Someone take a little smug.
That's just my face.
I just-
It's like, I came in and I realized the mic was still on. I turned it.
Oh, no.
Never mind. Their lives. I didn't hear anything on YouTube. To make you feel better. I wasn't watching. Everyone else was.
And nobody will watch it. No. This is- Just make sure. I think you can't really hear clearly. I don't know exactly what happened, but it's not really legible. We can go. Just a little control. Lesson learned. What is it? Extremely spread. So they're gonna stay as my grandparents role. I think some arrangements maybe made for them to like temporarily. Well, they jump back. Even though they like spend a few weeks in Shanghai and they go back to Vietnam and spend a few weeks. Yeah. Because my grandfather and yeah, Again, more. And I've heard Sid talk about wanting to move here, when they're old, to stay with me. I don't know how that's gonna play out. Really? Yeah. Yeah, I have issues with school. So that report is not going to. And I just panicked a bit. Feel like it's all. Trying to calm myself down. I don't think people are gonna message when they see it. There's no judges. Yeah. So does Aries go to private school? So kindergarten is public? Right. So is there a distinction between private and public? Are there private kindergartens? But you didn't like it? She didn't. Doesn't sense me. Okay. It's over 40, right?
That's what I was thinking of.
Just like.
Yeah, there's like some, the ladies are taking notes, the kids and stuff.
You messed up there.
No, I don't think you messed up, it's just. It's there, they're right. You think you messed up?
Like getting it wrong. Getting
What do you-
jury.
Oh, but we got rid of jury 12, right? Yeah, I hate that.
Well, that was. Oh, I was able to again. Now I can.
First phase on. No, it's right.
Just.
After you guys were talking about who knows what.
Those talking.
You have the thing where.
Do you like MS? See the first one?
That one,
The first one.
oh, is one more? Now I can't see anything.
No. Wait. Can you read it 1 minutes? What do you think? Just looking at these? Are there more?
Yeah, there was one more than this one.
Action.
Which,
Which one?
the bottom one,
It's
With two screens.
this one. Oh.
Would it be improper for me to interrupt the draft? It's okay. I don't think it would. Make it excellent. What would you want in it? That could be useful, right? Yeah. Next time.
Next time.
It's a clipper.
That's interesting.
Right?
Would be interesting.
It'll be interesting.
See, but you're in a gag order. Well.
I don't think we could. Any basis in it.
So, right out.
Their experiences. Yeah.
That'd be mine, yes.
Yeah. Yeah. That makes sense. Yeah.
But you never know what's going on.
You don't.
Yeah, that's always fun.
I wish they recorded the deliberations. And we could watch them as the time.
That people would be candid, they say.
Yeah. It's just secret with the attorneys.
That would be, it would be interesting to learn a lot.
There's that BP case. It's actually, I think, wife leads a
Well, like-
decision to engage the.
If you got other questions, getting close.
You know, usually,
No. Okay, so you're a juror.
You know, and
Can't
then
set that.
with BP.
You're a survivor.
At least the mediation phase. And I knew that only that because just in general. Do not like to
Set
speak for
back.
myself, or it's because they would prefer a female woman or something. That's my fault. And I wonder if having a female lawyer makes them more comfortable. It's just like.
Maybe they weren't close. Maybe it was going
being
through.
clients instead of having.
They got through all the questions. And they were like, well, I want to know how much the attorney fees are before we award them. Right? Because we asked them specifically the other things to award. And they want to know how much, which, hey, by law, they should know.
I know.
It's only ruling that I really feel like you are wrong. Like, you know what I mean? Like, everything else is like gray. I played that one. It's kind
But
of
they're
like,
not.
I think so too. Yeah.
Well, also, lost that meeting because they got me first, or something.
Yeah. I wish we could see the handwriting. I guess we can.
Yeah, we could. Although,
You'd guess who was writing it.
he seemed to have a hard time reading it. Like, I think this says, but
Yeah.
which man?
I was 33.
Yeah.
It's either 33 or it's so valid bar owner. That's a man. Hey,
What?
gonna put bets on who the fourth person is?
Yeah.
Yeah.
Yeah, what's your plan?
Like $5, like $5.
Well, I don't have cash. Well, Yasha can just transfer my salary and you
Direct deposit.
direct deposit and. Yeah, what's your bet?
Well, we have several bets. So one, is it a man or a woman?
You can only put in one bet. Well, is it $5 for each bet?
Sure, why not?
Let's lower that to $2. So I can put in two bets.
Okay,
Okay, you go ahead.
man or woman?
I have a specific person in mind. so
Okay, I'm thinking 33.
33 is which person?
The older black male. Is that who you
Yeah,
think?
yeah. So We can both get $2 and you probably after.
I guess I have to,
Wait, what's your thing with the person?
yeah.
The
Well,
social
there's-
Speaks.
Yeah, that's one concludes the jury. Oh, okay.
Find out.
You know, when that person came to me. Like some. I feel like it would be. Oh.
Are you kidding me?
No, it's like, well, like, well. So it's always the assumption. Well, there's the like. Where's the power? So. Yes. Yeah, it's pretty good.
I really do like, yeah.
Typing is definitely, it's much better, like, similar, like. Really? Oh, yeah. Oh, yeah. You should go to Taipei and like. trying to get it toward TSMC. That'd be cool. People that blow it up. Before when you do. Well, no, I mean, they probably have that place. Why are they? Just in case you take over. I mean, they probably have a plan. For critical infrastructure. They're already building the facility here, right? I mean, that has their joint venture, I believe, or TSMC building. Yeah, but they're running some pros. Actually getting the workforce here. Okay. Like we have to. It's always been a challenge. And then like the ASML prayers. That's not actually like a big facility. Those take a while. They only like make a company that much how to make. They can only make so many here. You know.
It's the same thing that. It's weird that we just have it.
And like we didn't go into say even if they would have been just. I mean, they're so much when they lag in force projection, they can't project the forces. They just want to. Yes. Like from a tactical standpoint, they can't really defend their over time. The only thing we can do is ready. Come on up. They would need everyone. They would need to basically like each all they have on China coast on with artillery. Got the combat. Then what city is nearest? Shanghai. I see there's some other bases. There are. It's like they know where everything is. So they know where I'm like happy to have
This is like
absolutely. That's what I have to.
they have this screen. Scary to China and getting everything in jump
Because I don't think
international trade English. It's like kind of things.
they think they are.
It's like around you know, yeah, that's gonna take.
Oh no.
Yeah.
He's pretty much position. So yeah.
Oh,
I think they have. Jaguar has his status. Big new snow. A moment ago.
what?
Yeah. You know? No. And the people back.
Because I know some Chinese.
We do have, it is very,
It is a verdict?
I don't, I just know that.
Okay, thank you.
Okay.
Always super. Yeah.
Didn't solve.
Oh, come to order. All right.
Let's go back on the record. I've been informed by Deputy Scott that the jury has been able to reach a verdict. Is there anybody else that we need to wait on? We haven't sent out an email or anything to anybody.
Ready to go, Your Honor. Thank you.
All right. If we could bring the jury back in. As they're coming in, one thing I'd query counsel on, in a criminal case, it's usually pretty straightforward. The jury stands up and reads it, and it's dramatic. In this situation, the special verdict has a lot of verbiage. My understanding of the law is that a verdict is published as soon as they hand it to me and I show it to you. Is there any requirement that they read anything, or upon inspection, would we assume that that is considered having published the verdict?
Okay with that approach, Your Honor.
All right.
So we'll be ready to arrive in the jury.
Do you need me to read the whole thing into the record? Thank you, Deputy Scott. Welcome back, members of the jury. I've been informed by Deputy Scott that you have been able to reach a verdict, and so I would ask the foreperson to identify themselves. Thank you, ma'am. Have you been able, and remind me of your jury number.
23.
In juror 23, have you been able to reach a verdict,
Yes, we have.
and was it unanimous?
Yes, it was.
Is that verdict form that we provided to you, has it been filled in, signed, and dated by you?
Yes.
If you could hand that to the deputy. You can have a seat, ma'am.
Oh.
All right, counsel, I have the completed verdict form as Court's Exhibit 3. It does appear to be filled out and in order. And I'll have the plaintiff inspect it first, and then if you can provide it to defense counsel. You can take that back to your team if you need to. Beginning with the plaintiff, are there any objections to the form of the verdict that we've received?
None to the form, Your Honor.
Any on behalf of PNC
Objections, Your Honor.
and Wells Fargo?
No objection, Your Honor.
This has always already been previously marked as Court's Exhibit 3. And so I would retender this into the record and have that constitute a publishing of the verdict. Any objections to that?
No objection, Your Honor.
All right, at this point, is there any reason this jury cannot be excused, beginning with the plaintiff?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right. Members of the jury, that concludes your service for this trial. At this point, if anyone wants to talk to you about this case, you're certainly welcome to do that. But that's not required. And there's no requirement that you do so. And so at this point, I'm going to take a moment to step back and thank you as well, but I'll make sure to leave the exit clear so you can make your way out from here. I especially want to thank you for the time and attention you spent to this case. And it's with the thanks of this court and the parties that we send you on your way. Thank you so much.
Right,
All right. And I'll ask the defendants collectively to submit to the court prepare a proposed judgment form for the court. And other than that, is there anything else that needs to be noted or heard on the record today before we adjourn, beginning with the plaintiff? I think we can make that happen.
Thank you.
All right, then hearing nothing else, then this matter will be adjourned. We're off the record. All right, thank you, man. Thank you for your patience.
Thank you.
Well, you don't have to lie. All right, thanks for your patience with me, everyone. Take care.
Thank
You
you.
as well.
It's got to be told, hey, go ahead and lock it. And, hey, again, I can do my paperwork, you know, do it. Give me 2 minutes, I'm gonna do it. Okay. $15.
Shut it down.
Uh,
Shut it down. You have somebody waiting?
yeah.
Somebody can go see. To come in. No, they not coming again. You want them to do it. You don't need them to come.
Animal, we got to go a lot, so.
Okay.
Yeah, I guess they-
Once you leave, you can come back in. Okay.
So I know the other 2 attorneys gonna come in.
No, it's in my shoulder. You just get.
So Court 585, Adam, wait for the remaining, more than lot, sensitive, clears. Courtroom is occupied by attorneys and the staff.
What do you need, Scott?
Uh,
I got your inspection sheet.
okay, thanks. Appreciate it.
They should them all over here, so.
Yeah, that's.
Oh, Nasha asked if you want action.
Right. Yes, for sure.
Yeah, because. You're welcome.
So more damages. Worse.
Oh my. Thank you all so much. Y'all are flying that tonight.
I missed my flight, so.
Oh,
We're not friends, so we're-
That's better actually, you know, just wait. The airport on a Friday is not like one of you stressing out at. Thank you. Yeah.
I wanted to, you know what, Drew.
I didn't understand. Yes, it kind of thought, but not. We were in. Sometimes we don't. Like that. We didn't know how that. Yeah, I don't want to make it. So, yeah. You be safe and see you on the next one, maybe down the road. Thank you.
You got everything? Oh, did he? I think they got everything. We got everything.
Yeah, let me see.
Do you get my phone? Hey, guys.
Thank you.
Thanks so much.
Yes, yes, yes.
Enjoy your 3 days. Bye.
Very much for serious.
Thanks for all your help.
Thank you for the service. Yeah, thank you for the service. Have a great weekend. You as well. You said. Take care, man. Thank you for your service, man. Have a good one. Yeah, enjoy the weekend. Take care, man. Thank you for your service. Yeah, no.
Hey, did you see Tanya?
Yeah, she came out in the hall.
I was looking for the jury.
We thought the jury was gonna come out from that side. That's